Application.
Application order for turn, please. Application. Wait. First, the applications and order for turns. Yes.
My lord, kindly may I be permitted to
Take the microphone.
mention the matter to be listed under the heading hearing, my lord. What is the urgency, my lord? My lord, a suit for declaration of a marriage of nullity was filed by the husband. That has been turned down, and accordingly an appeal has been preferred before this honorable court. In the sidelines, my lord, the wife has initiated a proceedings under 125. My lord, there was a direction passed by the Honorable Justice Joy Shen Gupta to expedite the hearing, my lord. According to direction of the hearing, maintenance case has been expedited, my lord. Until and unless this appeal is heard out, my lord, I will be prejudiced, my lord.
125.
My lord.
No.
I have my lord's kind leave to mention that we're mentioning upon notice, my lord, there was a direction by your lordships that, my lord, in the injunction before the honorable trial court, my lord, we were supposed to file an affidavit in opposition. This is a trust matter which was heard extensively by your lordships. But we have filed, my lord, we have, my lord, affirmed the affidavit within time. We have served on the other side within time.
Filed beyond time, it is not being accepted.
It's not being accepted. We have filed, my lord. It's in the court records. But, my lord, there's a direction that unless an extension is granted by the honorable court, we have filed, my lord, formal
File a one-page
applications.
application.
We have, my lord. We have filed. I'm praying for
Applications we
inclusion.
are taking without even
So the
mentioning.
only difficulty is, my lord, the matter is kept tomorrow in the second half. My lord, that's the only difficulty. My lord, we are ready to argue the matter. My lord,
Mr. Bag, if unless this application you mention, unless the file comes, we cannot give it in the list.
my lord.
If the file comes, immediately we'll give it in the list.
My lord, we will. My lord,
Yes.
may I only hand over this.
Appeal, my lord.
Very
Do not-
deeply obliged.
Matrimonial appeal, my lord. Kindly do not refuse, my lord. Quite some time I am approaching your lordship, but
So we are not adding because we cannot. There is no use in prolonging the list. Let us dispose of some appeals. We are not being able to dispose of matters.
if my lord keep the doors shut, then where the
So,
litigants will-
Mr. Dotto, it's an absolutely wrong notion that we are keeping the court shut. We are working day and night.
No.
And
I-
even
not only-
sometimes we burn midnight oil. So we are keeping the courts always open. So let this notion be dispelled that we are keeping the court shut. We are just not wanting to waste paper space, because you may have some consolation if it is added in the list. But if you can't reach the matters already in the list, Mr. Dotto, it's no use adding. That's why we are refusing. We are not keeping the doors of the court shut. And
My-
every day we are touching to reach as many matters as can.
My lord, kindly don't take me amiss. I am
No,
not
Mr. Dotto, not at all. But this wrong perception should go that because the mentionings are not taken, many people have that perception the court's doors are being shut. We are not shutting the doors. We are throughout the day, not throughout the night, but most of the night, we are working for you only.
No.
So unless we dispose of some appeals, there's no use adding in the list. That's why you are refusing.
No, I'm keeping record on the
And order
list.
41 and application, we are regularly adding. Appeals also, we are touching most of the days. So let us see. Yes.
Some
Lojima matter, my lord.
deeply, my lord. That's why you
We understand, but not right now.
My lord, Lojima matter, my lord.
Lojima, yes.
My lord, this is an appeal pending since 14 to 2025. And the injunction,
2025, no question, no, sorry.
My lord,
Hearing matter or order 41? Admission.
no, it has not come to the list till now, my lord.
It's a FMAT or what?
FAT.
It won't come in the list. At the hearing stage, it will come. Unless you file an application, there is no provision of admission in our court. It's automatically deemed to stand admitted. So you take steps for serving notice on the respondent.
Obliged, my
You
lord.
approach the department, put in cost, the notice will be served, the appeal will be ready. After the appeal is ready, you will have a chance of hearing. Yes.
Obliged, my lord.
mentioning for hearing, my lord.
Hearing we are not taking.
Hearing.
Yes. First the advocates. Yes.
My lord, mentioning for application, my lord.
Application. Yes. Yes.
My lord, ex parte hearing তো খুব আর্জেন্ট আছে স্যার।
আপনি কি নিজে অ্যাপিয়ার করছেন না কোন অ্যাডভোকেট আছে? অ্যাপিল হিয়ারিং
স্যার
অ্যাপিল হিয়ারিং আমরা অ্যাড করছি। হ্যাঁ,
এক্স পার্টি
এক্সপার্টি হলো অ্যাপিল হিয়ারিং আমরা অ্যাড করছি না। হিয়ারিং লিস্ট এখন দেখলেন তো রিফিউজ করলাম।
অসুবিধা জজ সাহেব
সরি না, বলেন না।
শাসকদল খুব টর্চার করছে কেস তুলে নেওয়ার জন্য,
জানি কিন্তু না।
কোর্টে আসছে না, এক্স পার্টি হয়ে গেছে, তাও আমাকে টর্চার করছে প্রচুর
ইয়েস,
কেস তুলে নেওয়ার জন্য।
হু ইজ অ্যাপিয়ারিং ইন ওয়ান?
My lord, item number 1, my lord, I am appearing for
Okay,
the my
what
lord,
is that?
plaintiff petitioner. My lord, this is a case of defamation, damage for defamation. On the ground of defamation, my lord, we
Your
contested.
suit dismissed.
Well, we contested, we filed my lord a written statement, and it was a decree in favor of the plaintiff. 10 lakhs rupees were direct to be paid at the defamation cost. And as per the order of this Honorable High Court, my lord, direction of the, I have deposited the said amount with the Learned Registrar General, High Court, Calcutta, and stay was initially granted. Thereafter, my lord, interim order was not extended till today. And some defect is there, my lord. I pray before your lordship, my lord, let the paper book be filed within a stipulated time.
Stay application is still pending.
Still pending, my lord.
He has deposited already 10 lakhs.
Already.
So we'll dispose of the stay application, pass the usual directions.
My lord,
You are appealing for the only respondent.
my only difficulty is that I have been briefed in this matter only today morning only.
That is
the
not
ma-
a difficulty at all.
Because
What is the
for-
difficulty in
a
that?
formal objection is to be required in the stay application, my lord. Because otherwise, my lord, even I have not submitted my wakalatnama also, my lord. So let the matter be taken up any day, my lord.
No, no,
This week.
no. It's your problem that you have taken a brief in the morning for a matter which is already appearing in the list.
My
Don't
lord,
take those matters.
I have been briefed today morning only, my lord. Kindly
You are not a
let it-
child, you are not a suckling baby that you are fed with the brief. You have consciously accepted the brief, knowing
My
fully well
lord.
that the matter is appearing in a judge's court.
My lord, my lord.
Why did you take the brief?
My lord,
Don't take the brief.
Let it be taken up tomorrow.
Sorry, sorry. No, this is not a ground at all, sir. Not a ground at all. It's your problem that
I
you take
understood,
matters
my
in the morning, knowing fully well it is appearing in the list.
I understand.
Sorry,
my lord.
don't do this practice. And if you do, you have to get ready. We have prepared ourselves within the recess period.
My lord, I understand. My lord. Ultimately, the
No,
litigant
we
will
have
suffer, my
taken
lord.
briefs in corridors and we have prepared ourselves during recess. If you did not get the time, it's your problem. The present application is an application for stay of operation of a decree directing the defendant stroke appellant to pay an amount in view of the trial court having held that the appellant is guilty of defamation. For sub next para, an ad interim order was passed subject to payment of the decretal amount, which has already been complied with by the appellant. For sub next para, learned counsel for the respondent opposes the application. For sub, however, we are of the view that in the event stay is refused, the appeal will be rendered infructuous. Moreover, the interest of the plaintiff stroke respondent is sufficiently protected by the deposit of the decretal amount by the appellant in the court. Next para, accordingly, can 1 of 2017 within bracket old number can 6360 of 2017 is allowed on contest, thereby granting stay of operation of the impugned decree till disposal of the appeal. Next para, there will be no address to cost. Next para, since the respondent is already represented through his learned advocate, service of notice of the appeal on the respondent is dispensed with. Full stop. The trial court record shall be brought by special messenger at the cost of the appellant, which shall be deposited within a week from date. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you.
My lord, there is some technical mistake, my lord. One is, my lord, memorandum of appeal to be preferred. That in the very first column in the appeal, that should be written. Memorandum of appeal preferred from the
To
original.
correct the memorandum,
My lord, that is
leave is
different.
granted to the learned advocate on record for the appellant to carry out the necessary corrections to the memorandum of appeal to remove the defect.
Yes, yes.
Item number 2, my lord, I
Yes.
appear for the appellant, my lord. This
Yes,
an
Mr.
appeal
Shen.
is against the preliminary decree passed in a partition suit, my lord.
My lord, on the earlier occasion, my lord, your lordship have directed the appellants to serve the copy of the CAN applications, my lord.
Not served.
Not served, my
Why,
lord.
Mr. Shen?
বলা হয়েছে মুখে বলেছিলাম যে CAN application দেবেন।
What's why there was, I didn't heard my.
Serve and come back day after tomorrow. We'll take it up day after tomorrow.
Fine.
Learned counsel, you are for the plaintiff respondent.
Respondent
count-
number 3ABC, my lord.
No, no,
3ABC.
my lord, 3ABC, my lord, it's the, they filed, my lord, written statement along with me, my lord. So far as the respondent number 1, he is the plaintiff respondent.
Yes. 3ABC, you contested along with them.
My lord.
Your interest is give a copy, Mr. Shen.
But that I can give in the course of the day, my lord. But my lord, he is not the.
ABC
effective-
means there was a substitution,
he was
but
the
it has not been carried out in the amendment has not been carried out in the application.
my lord, most probably in the memorandum of appeal is that
Memorandum it has been.
it has been carried out, my lord. My lord, I was humbly praying, my lord, the usual order may be passed, my lord. Limited usual order may be passed, my lord, in a partition suit, my lord.
Give a copy and come back tomorrow. Come back tomorrow. Learned counsel for the respondent numbers 3 series submits that no copy of the application has been served on them Full stop. Learned counsel for the appellant submits that the said substituted respondent's predecessor had contested along with the present appellant in the trial court. Full stop. Be that as it may, comma, a copy of the application be served on the learned advocate having instruction to appear for respondent numbers 3 series during the course of the day. Full stop. Let the matter be listed under the same heading tomorrow. Come back tomorrow. And Mr. Shen will give you liberty on the reverse page of the cause title. Just carry out the correction in the stay application also, please. Ask your learned junior to do that. Actor line add kore daw, leave is granted to the learned advocate on record for the appellant to carry out the necessary corrections, incorporating the names of the substituted respondents on the reverse of the relevant page of the stay application during the course of the day. Thank
This is my application for withdrawal of the money deposited, my lord, in the court pursuant to the.
Why two appeals, Mr. Datta?
Only one application, my lord. 4 নম্বরটা কেন এসেছে?
হ্যাঁ? না সে তো বলছেই আমি যে দুটো অ্যাপিল কেন
One is dismissing my suit for my lord, this for declaration and for injunction, and the other sides, my lord, defendants, my lord, counter claim which has been allowed.
What is the counter claim?
The counter is, my lord, that is for, my lord, for eviction and to take back possession.
Your declaration was tenancy.
Declaration, not the declaration, is the permanent injunction against them.
Your claim is that you are a tenant.
I am the tenant. It has
They say you are a trespasser.
you are a trespasser. This is that matter where 4 car parking
You have
spaces-
deposited occupation charges. Why should it be permitted to be withdrawn?
It was the occupation because I was allowed to be declared to be as
Your granted stay.
no. Initially, it was granted stay as a condition of stay.
Occupation charges.
Occupation charges was given.
We'll think about increasing the occupation charges. Why should we permit you to withdraw?
decree that.
2019 appeal.
Your lordship has been pleased to allow the appeal, and the
Appeal has been allowed.
yes, my lord.
Oh,
My lord's order is there, my lord.
so we have allowed your appeal.
14th, yes, my lord. 14th of
Let us
June.
recall that order so that you don't.
That is 4 car parking spaces where
Oh,
the
that.
owners. Yes, my lord.
All right. Yes. We should have understood by looking at both of you.
But it is a new phase.
Only
No, he was there on the last occasion. No, he was
He
not.
was not there.
That's
the learned advocate on record
Shown
has
up.
not come today, Milord, due to his illness. Milord, kindly
Let him remain at home, take rest. No difficulty will permit him to withdraw.
no, Milord, only one.
Appeal has been allowed, but
Milord allowed, but
no, Mr. Datta, only
conditional
one.
stay was there.
No, yes, he is right, Mr. Datta. Why should we permit you to allow? Because that was as condition of stay. That is the occupation charges you paid because during that period you were in possession.
Because they are not my landlord. My landlord was someone else.
Will permit them to file an opposition to this, Mr. Datta. It is required
Let
in
him.
this way. The present application has been filed for withdrawal of the occupation charges deposited by the appellant in terms of an interim order passed in connection with the appeal. Full stop. The two appeals arose respectively out of a suit by the present appellant for permanent injunction on the ground that the appellant is a tenant in respect of the suit premises. Full stop. The case of the appellant was that the respondent is not the landlord of the appellant. Full stop. Next para. On the other hand, comma, the respondent had also filed a suit for eviction, which was decreed by the impugned judgment and decree, comma, giving rise to the present appeal. Full stop. Next para. Upon hearing both parties, comma, this court had allowed the appeals, comma, thereby dismissing the eviction suit of the respondent. Full stop. Learned counsel for the appellant submits that since the stand of the appellant has been vindicated that the respondent is not the landlord of the appellant, comma, the respondent was not entitled to the occupation charges even during the pendency of the appeal. Full stop. Next para. Learned counsel appearing for the respondent, comma, however, comma, submits that the respondents are entitled to the occupation charges, comma, which were granted by way of condition for the stay obtained by the appellant. Full stop. as such, since the occupation of the suit premises was actually enjoyed by the appellant during the relevant period, no question arises of permitting the appellant to withdraw the deposited amount. Full stop. Next para. On the prayer of the respondents, the respondents are directed to file their affidavit in opposition within a fortnight from date. Stop. Reply, if any, shall be filed within a week thereafter.
Or only give a returnable date.
The application shall be listed on July 23, 2025 for hearing under the same heading. In all probability, we will allow it, because if you are not entitled, then occupation charges, yes, they occupied.
But Milord,
But we'll look into our judgment also.
Eviction, Milord. Thereafter, the stay was granted upon payment of occupation charges. He was declared as
Understood.
a trespasser.
Understood.
Granted decree, my lord.
Yes.
But
Decree
this,
of
he is wanting for withdrawal of the amount deposited during
During
pendency
that
of this,
stay.
this appeal
Yes,
here.
yes, Milord. Yes,
If we allow the appeal ultimately,
but he was permitted to stay, Milord.
Because I am
permitted,
paying-
but whether you are entitled to that amount, that is the difficulty.
I am paying
That
regularly.
amount cannot be blocked in the court. Either of the parties has to get it back. Either he gets it back or you take it.
Yes.
If you are not entitled, we'll permit him to withdraw. And if the original landlord comes up, he'll deposit wherever.
I am depositing with the original landlord in the meantime.
In your reply, you just point that out also.
Yes, my lord.
Because they'll take this point obviously in opposition and point out that you are already paying to it. Thank you. But let it be on record formally. No, sorry. Mr. Bose, you are for the appellant?
My lord.
You are for the respondent. What is the matter about, Mr. Bose?
My lord, revocation of a grant of probate. My lord, the appellants.
Allowed or dismissed?
Revocation allowed. So, my lord, the appellants before your lordship were the executors and legatees to the will. My lord, the facts are such that the applicant of the application for revocation of probate was a third party. Now, he claimed that the property has been sold to him by someone who had purchased it from the heir in intestacy, from one of the heirs in intestacy.
All right.
Now, if I like, we have prepared a chart, but the only
Here in intestacy, obviously after the demise of the testator.
yes. Now the difficulty is that if your lordship will kindly
So he claims through that heir.
no, the only factual, my lord, situation is that, my lord, admittedly, the testator had 1/3 share in the property, 1/4 share in the property, 1/4 share in the property.
Some fraction, yes.
And upon her death, she had no children. So it reverted back, since it is from her Sridhon. So it reverted back to her brother.
All right.
Now the brother was the 3/4 owner. Originally half.
So became the total owner.
Became the 3/4 owner.
Oh.
So he was 3/4. Now the question is that if upon the death of the testator, if she had died without leaving behind a will, then, my lord, the entirety devolved upon the brother. Now she left behind a will, so the brother remained the owner of 3/4, not the remaining. Now, my lord, the brother apparently sold it to X, and then X filed a proceeding against the brother for recovery of possession. It was a deed of conveyance, but admittedly possession was not given. So against the brother, a proceeding was initiated by the first transferee for recovery of possession. That conveyance made, possession not given, so recovery of possession.
Yes.
Well, during the pendency of that suit, the first transferee sold the property once again to the applicant on the revocation application.
All right.
So he got himself substituted in that suit. And, my lord, there was an ex parte decree. So naturally, the brother never contested the suit. So he got an ex parte decree. He put the ex parte decree into execution. So, my lord, these are all family members. These are the sons of the same brother who had sold the property.
Oh, there also.
Yes,
Yes.
yes.
Very, yes.
The brother who had sold the property, we are the sons of the brother. Now, my lord, naturally, this is the residential house which is being sought to be sold. So, when the decree was sought to be executed, we resisted. Application filed under Order 21, Rule 99. Eventually, my lord, that application was allowed. In the interregnum, he came to learn about the probate proceedings, and the
application was allowed by holding that his transfer was bad.
No,
his application was allowed.
By holding, Malat, entirety of the finding is in my favor.
Right.
Reasons, everything is in my favor. But eventually, the trial court holds that he had a caveatable interest.
All right.
And he ought to have been cited. And the court comes to the finding, because there was a transfer, before the grant, he ought to have been cited. This is the limited question. Whether a subsequent transferee.
But stay, Mr. Bose, stay has been granted, additive stay.
No.
There is no scope of grant of stay because stay would virtually allow your appeal before it's heard. Injunction we can appreciate. Is there any averment regarding injunction? If there is not, we'll give you that liberty, file an injunction application, we'll definitely injunct both parties.
Well, we've sought for stay.
Stay.
Tell your lordship why. Well, what he is doing is, well, that Order 21, Rule 99 has been allowed. I'm sure he must be in appeal.
Suppose if the stay is granted, then the probate will revive. That will be allowing your appeal before hearing. Before hearing the appeal.
So, well, at least, well, some nature of a status quo to be maintained.
We were wanting some pleading in your application. If there is no pleading that he's trying to transfer, then we can't grant.
You will kindly take from paragraph 13 onwards.
Yes.
In fact, para 14.
There is nothing, no averment he's trying to transfer anything of that sort. We have seen from paragraph 12 onwards, in fact.
Yes.
Because those are the relevant paragraphs in any such application. We'll give you liberty, immediately file an application, Mr. Bose. We'll record why you are not granting stay.
Here, my lord, grant has been revoked, my lord, and it has been directed that to prove this will in presence of the respondent, my lord.
That proceeding is going on.
No, that proceeding is not going on. I am, my lord, humbly praying, my lord, if my lord, if the appeal remains pending, my lord, now till date, my lord, the witness to the will are all, my lord, alive. My lord, if
you are the sole respondent.
My lord, I am the sole respondent.
Suppose we'll grant you that liberty to file an injunction application, but we will direct the appeal to be proceeded with. I mean, in the sense that
may I just
you prepare paper books and
may I just indicate this? If your lordship sees the impugned order, what my learned friend is saying is, the brother from whom his transferor had purchased, the brother was cited. And
but at that point of time, he had already transferred.
He had already transferred, but he was cited. In spite of being cited, in spite of receiving the special citation, he chose not to participate in the
probate. Does not bind him if it has already been transferred.
No, but that's the difficulty that, my lord, in a
brother didn't have any title in the property. Brother could not have claimed title. So therefore, citation on the brother who does not have title.
No, brother was a natural heir on intestacy. So
otherwise,
he ought to have been cited anyways. So he did not oppose the grant.
Yes, but that may or may not bind them, probably does not bind.
That's what I'm saying, my lord. Now the question is that, now I could not have any knowledge about the subsequent transfer.
Suppose we'll simply say what we said.
Well, I'll tell you, lordship, what my learned friend pointed out, that in the meantime, my lord, so my lord, because after revocation of the grant,
yes,
so now I have to prove the probate. Now, if I succeed in the appeal, so well, it will become a exercise in futility. So well, at least stay the operation of the order, not because of anything, because at least stay the proceeding, well, to prove the will.
So let us see the ordering portion of the impugned judgment. The probate case has been revoked.
Yes,
revived, sorry.
The 263 allowed, revoked, hereby revived.
Yes, Mr. Shen, we were under the impression that the probate was revived. But here the probate case was revived and it's going on. That will render the appeal infructuous. We'll stay
My
there.
lord, I was humbly praying, my lord, let the proceedings in the trial court continue, but no final order be passed, my lord. My lord, because my lord, still we have a chance to cross-examine the witness. My lord, if the appeal is kept pending,
We'll do
my lord,
that, Mr.
Well, if he doesn't have a caveatable interest,
No final.
no final order be
well, I
passed.
tell you,
final
Lordship,
order, that's it.
Partnership.
may I just indicate this, my lord? If he doesn't, if I hold, because our case is that he doesn't have a caveatable interest.
True. No, let the other, like a partition suit, let the other formalities be complied with, because the witnesses will be probably not in the world of the living when this
Appeal will
this is
happen.
over. So he has a point there.
Well, Lord, the executors
We'll
are the
restrain
legatees of the will.
restrain the probate court. We suppose will pass an order to the effect that the probate court shall not pass any final judgment in the probate proceeding. We'll restrict
Without the
that
leave of the
without the
honorable.
leave of the court, the usual order, and we'll direct it to prepare paper. So there is no scope of grant of leave to file injunction or something like that. We'll stay to the extent that no final judgment will be passed in the probate case.
Very well, very
Learned
well. And my
senior
lord, and
counsel-
my lord, and my lord, would it be your lordship also consider, my lord, considering the facts that the applicant of the revocation application should not create any further third party interest, because he has this has
You have
this
to
has
apply for
happened twice. It has happened not once, twice.
Then you have to file a proper application.
Very
for
well,
it.
I'll file.
Learned senior counsel appealing for the appellant submits in support of the stay application that it is questionable as to whether the respondent, at whose behest the testamentary court allowed a revocation application and revived the probate proceeding, has title in the property and stroke or any caveatable interest. Full stop, next para. It is argued that in the event the probate proceeding, which is being heard afresh after the impugned judgment, is permitted to be concluded, the present appeal may be rendered infructuous, and it will be a futile exercise to permit the proceedings to continue in the trial in the probate court. Full stop, next para. Learned counsel appearing for the respondent submits that in the event all further proceedings of the probate proceeding are stayed, the attesting witnesses to the will and other relevant witnesses, who would be necessary to prove the will afresh, might not be available at the end of the disposal of the present proceeding. Full stop, as such, it is submitted that the probate proceedings be permitted to be continued. Full stop, next para. Upon a consideration of the balance of convenience and inconvenience of the parties, we find that in the event the probate proceedings are permitted to be continued, the apprehension of the respondent of non-availability of the witnesses at the end of the litigation might be allayed, ALLAYED. Full stop, next para. However, at the same time, the apprehension of the appellant that the present appeal may be rendered infructuous is also justified. Full stop. Thus, to strike a balance between the two, the final judgment stroke deemed decree in the probate proceeding ought to be stayed. Full stop, next para. Accordingly, can 1 of 2019 within bracket old number can 11156 of 2019 is disposed of on contest, thereby permitting the testamentary court to continue with the probate proceeding. Full stop, next para. However, no final judgment stroke deemed decree shall be passed therein without prior leave of this court. Full stop, next para. In view of the no order is to cost code. Next para, in view of the appearance of the respondent through his learned advocate, service of notice of the appeal on the respondent is dispensed with. Stop, next para. But if the records come,
records need not come, my lord.
Need
My
not-
lord, this is,
may not
this
be-
is a
May not
point of
come, may
law,
not
my
be.
very
May
well.
not be.
Since the probate proceedings have been permitted to be continued and the relevant documents have all been annexed to the stay application and stroke or are available with the parties, the trial court records need not be called for to expedite the appeal. Full stop, next para. the appellants shall prepare and file info.
Respondents shall, my lord, we are ready, my lord.
You have all the papers.
Yes.
On the prayer of the respondent, comma, the respondent is directed to file the requisite number of informal paper books without comparing with the records within 6 weeks. Within 6 weeks from date, full stop. The appeal be treated otherwise ready for hearing, comma, subject to such filing of the paper books. Full stop. Next para. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is made ready for hearing.
Will you to all
Right.
lordship's pleasure to fix up a date for appearance of the parties in the trial court? Because, my lord, again, notice will go, my lord.
No, Mr. Shen. The trial court may be in difficulty. We don't know the situation of the trial court.
Right.
Better approach the trial court and get a date there. Mr. Shamol is also there.
Right.
He's the chief architect of the travel. Yes.
This is my
Yes.
application.
Yes, please.
But I appear for the respondent wife, my lord.
Mr. Shen, your
Husband, my lord.
strike rate has to be decreased now. So statistically, you're in a bad position. Yes. What is the matter, please?
This is arising out of matrimonial suit where the decree is suffered by our appellant wife.
You have remarried, Mr. Shen?
My learned friend has
My lord, question is, my lord, both the parties are settled in their own life, my lord. My lord, she has gotten petrol pump, she has gotten business, my lord.
Petrol pump need not fulfill all the necessities of
My
life.
lord, she has got separate business. The husband is also settled, my lord.
He wants to live with you as a wife.
But that is not possible, my lord. According to him, my lord, 498 proceedings filed.
What are the respective ages of the parties? Approximately.
37 is the
30
wife
37.
and husband possibly 40.
40.
Should we send it for mediation?
Fine.
For separating ways also if necessary.
Mediation failed, my lord, twice.
No, mediation, the effort was to join you together.
Once it was sent by Justice Biswajit Basu under section 24.
That was in section 24, not in this appeal, my lord.
In this appeal, not in this appeal, but in the trial court, the learned judge has tried.
No, if we make it clear that, or if you agree to part ways, then we can record that.
Your lordship will kindly see only one.
No, we don't force you at all.
No, I am only trying to point out. Decree was granted on the ground of cruelty. Desertion was not allowed. That was disbelieved. Now, cruelty by whom? Among many grounds, two ground is cruelty inflicted by the Honorable High Court.
Like how?
Like, Division bench has directed the husband to deposit his passport. That is a cruelty.
No, at the behest of the wife. Must be.
But
High Court does not act of its own. We don't have any interest in it.
he has violated the condition of anticipatory bail. He left India. Then a cancellation application was filed.
But that was deemed to be at cruelty.
That
By the
was
wife.
one of the ground of cruelty.
And what is the other ground?
Other ground is that Justice Subhasis Dasgupta has sent the matter from Barasat to Malda court. That is one of the ground of cruelty.
Seriously?
That is what was not in the petition, my lord. That was the submission of the learned advocate.
That is
in
the finding of the court.
My lord, court came to that finding, well, with other findings also. My lord, fact
the finding
remains,
of
my
the
lord,
court.
the domestic
No,
violence
if the wife wants to proceed, we'll grant an injunction and then can send you to mediation. We'll grant an injunction and then send you to mediation.
domestic violence case was filed, my lord. with the
Understood,
wife.
Mr. Chen. In
That-
matrimonial suits, there is always acrimony. So,
That was dismissed. Against that, no appeal has been preferred.
no, if you
So,
suppose you agree to, agree to file something before the mediator to the effect that you don't press your charges regarding cruelty or something like that,
that we can
or that can be resolved
That can
between the
be resolved.
parties.
that can be done.
We'll dispose of the injunction application, we'll grant injunction. Should we, unless you agree, we won't refer it to mediation. If we refer to mediation, we will make it clear that it will be open for the mediator to consider whether you will part ways or live as husband and wife. Whichever way, both will be kept open by us. If you agree only, then we'll send, otherwise you prepare your paper.
Difficulty is my learned friend's client. I don't know whether his client has informed to him.
Has?
Informed to my learned friend. His client has already got married, not official, in 2020. And in
So why put him in more trouble?
that is the reason why he wants that he go to the mediation.
No, no, my lord,
You can point that out to the mediator also. That can be taken care of. I mean, If he has already contracted marriage, he would definitely had opposed this injunction application.
Not
If
officially.
he is living
I haven't
together
got
with
any
some
proof to
lady, then
that
it's a different proposition. We are not
I
interested.
haven't got proof to that extent. That is the reason why the witness has stated.
My lord, in that
last-
event, kindly take you up Wednesday, my lord, I will take instruction.
Take instruction whether they have married.
And today is the date.
If married informally, we will injunct
Today is the
him
date
from
of.
marrying formally. Let him go on living happily with the wife, with the lady. We don't have any objection. But if he has formally married, then the injunction does not survive.
That is
But difficulty
He
is,
has
my
not
lord, the
formally
appeal
met-
hearing will take place, my lord, another 5 to 7 years.
That is the difficulty for
Your
both
lordship
of
can
you.
take up the application and appeal together because there is no.
So easy for you to say, and the other matters suffer.
He told me,
cannot-
my lord, that he will make such submission.
Not possible.
But my learned friend made such submission in earlier occasion.
So we'll take it up day after tomorrow. Let him take instruction.
Fine.
Learned counsel for the appellant submits that it has unofficially been informed to the appellant wife that the respondent husband might have contracted marriage in the meantime. Full stop. Next para, learned counsel for the respondent seeks some time to seeks an accommodation to take appropriate instructions in that regard. Full stop. Accordingly, let the matter stand over till July 2, 2025, when it will be listed under the same heading.
Grateful to us.
Come back, please. If necessary, we'll refer it to mediation also. No difficulty. Mr. Paul, you are to take instruction actually, whether it should be referred to mediation for either way.
I will take instruction, but
If you don't agree, we won't send. No difficulty on that.
Because twice it has failed. That is the reason.
Failed on a different context. Maybe you have a talk with your client. We have made our minds clear. We'll keep both options open to them.
I will take instruction.
I beg to appear for the respondent. On last occasion, my lord has directed us to file an affidavit with regard to CAN 3, an application for amendment they have filed. My lord, we have served it upon them. They have also served upon us their reply, my lord. CAN 3 is the amended application for CAN 1, my lord, which is a section.
What was the defect? You have removed the defect.
Defects were all removed. There was no defect.
My lord, there is a section 5 application. There is
Section
delay
5,
of 267 days, my lord.
That
Section
is
5 has
what
to
is
be heard
contested.
first.
My lord, what had happened today, my lord?
The CAN 3 is not the section 5.
CAN 3 is the amendment of the section 5.
I'll just remind, my lord, there was in CAN 1, but before that, I'll just indicate another thing. My learned friend came and told me that Mr. Chakraborty is stuck. He will not be able to come.
He was stuck in traffic, my lord. There is a water logging.
now
He
he's
just
saying-
reached, my lord. He just reached. I have
Then
informed him.
mental preparation he did not.
My lord, my lord.
Take the affidavits, take it up today, tomorrow.
Yes,
Oh, whatever.
because I'm being led by Mr. Devjit Mukherjee. I told him he's going to another court.
Mr. Mukherjee and Mr. Chakraborty are hand in glove. You two are suffering. No difficulty on that. The affidavits in opposition and reply to CAN 3 of 2025 filed today be kept on record. Full stop on the prayer of learned counsel. Let the matter stand adjourned for the day.
My lord, let it retain its position.
Day at the adjourned for the day. How can it go
Grateful.
anywhere else?
Grateful, lordship.
It doesn't have any other place to go.
Grateful, lordship.
No, unless older matters applications are added.
My lord.
Because the
My
office
lord.
automatically.
That is CIS, that is up to CIS.
Right, right.
Grateful, lordship.
You know better than us, in fact. The advocates know better than the judges. 8, yes. Yes, please.
Yes. My lord, last
appearing for
You're for the respondent.
respondent plaintiff.
yes. My lord, last time direction was to file the affidavit to service, followed by the cure the defective. Defect has been cured already, sir. My lord.
One defect is the delay itself.
Yes, yes, yes.
What was the other defect? Let
So
us see the other.
yeah, this is the court fees regardings. It has been cured.
Yes, remove. So,
My lord.
what is the appeal against?
My lord, actually, senior advocate Mr. Rahul Arya appearing in this matter.
You have preferred the appeal against him.
No. My seniors.
What is the appeal against?
Appeal against my lord.
Why are you laughing? It's very ridiculous something.
No, actually, which I mean jumbled up due to just last
What
time
is
I
the
got the
appeal
exception.
Partition suit. The
Preliminary decree
preliminary
granted against that.
granted against that.
What is the reason for the delay? Let us hear you on this.
I'm for the
Yes, so what?
DG.
What reason has he given?
He had been suffering.
He's jumbled up, so we should
He had been suffering.
suffering. Let us see.
But kindly have a look to page 16.
Page 16.
Inner page of the judgment, page 8, last para. At the time of cross-examination, he admitted.
It was an expiry degree? No.
Content.
He admitted what?
In our page 8.
In our page 8, yes.
Para.
During his cross-examination, admitted is rightful owner. So you say there is no substance in the challenge itself?
Yes.
My lord, today I am could not holding the brief also.
Why are you not holding the
No,
brief?
actually, my senior is holding the brief. He's last night.
He doesn't give copies of briefs to juniors.
Actually, due to this sort of time span. Actually, last night he got the actually road accident, and now he's in deep troubles. So I'm seeking adjournment.
Section 5, you prepare yourself.
Yes, but I could not holding the brief, my lord. This is the only reason.
In section 5, we will not consider the merit while granting stay. We will not grant. We will consider the merits of the case. Section 5, we won't be. Let us see the reason given in section. Can 2 will not dispose of today. We will hear you on that.
But at the time of before passing the preliminary decree, he has no objection.
No, that's not a relevant consideration in section 5. We are allowing the section 5 stay application. Will record your objection. Keep it tomorrow. Heard learned counsel for the parties. Full stop.
No, my lord, he is hospitalized.
Heard learned counsel for the parties. Full stop. Upon going through the averments made in the application for condonation of delay, comma, we are satisfied that sufficient cause for the delay has been made out, inasmuch as during the relevant period, comma, the appellant was seriously ill. Full stop. The medical certificate annexed to the application corroborates such stand. Full stop. Accordingly, can 1 of 2025 is allowed on contest, thereby condoning the delay in preferring FAT 125 of 2025. Without full stop, there will be no orders to cost. The appeal stands appeal is deemed to stand registered and admitted. Full stop. Next para. Can 2 is an application for stay. Full stop. Learned counsel for the plaintiff respondent points out to the observations made in the impugned judgment to the effect that in cross-examination, comma, the defendant's witness categorically admitted the title and respective shares of the parties, comma, on the basis of which the impugned judgment was passed. Full stop. As such, comma, it is submitted that there is no prima facie case made out for grant of stay, and the appeal ought not to be entertained. Full stop. Next para. At this juncture, comma, learned counsel for the appellant seeks an adjournment on the ground of absence of his senior. Full stop. Full stop. Hence, comma, let can 2 of 2025 stand adjourned till when will come? Tomorrow?
No, sir. He's seriously injured. That back.
You prepare yourself. You will grant time till day after tomorrow. If he does not come, you have to move it. Accordingly, the can 2 of such and such is adjourned till
next week at least.
No. Adjourned till July 2, 2025. You have to come prepared. The affidavit of service filed today be kept under. If he does not come, you have to come and do the matter. Yes.
Your Lordship, I'm appearing for the petition.
Give us half a second.
Your Lordship would see the last order.
Just
There
give
was-
us half a second. Yes. Yes. What do you say?
I'm for the appellant, Your Lordship.
Yes.
If I'm for the respondent,
Yes.
Mr. Banerjee is appearing.
Which Mr. Banerjee?
Mr. S.S. Banerjee, Shiv Shankar.
Yes.
He's stuck up in Girish Park, the traffic bottleneck.
Girish Park will take much time to come then.
My lord, it's a little passover, short passover, my lord.
Short passover won't do because Girish Park there's a metro problem which has spilled over to the road.
1 hour passover, my lord, I've been told that he will be coming somewhere.
What is the application for?
Your Lordship would see the last order. There was a direction on them to file their opposition. They
Are you prepared? Have you
Petition is ready, my lord. It is with him. He will come.
We'll keep it tomorrow then.
Lordship.
We'll keep it tomorrow. You are ready with your reply also.
Your Lordship, we have the earlier opposition that was served on us. Apparently, the advocate gave an NOC.
Pardon?
The advocate on
You want
gave an NOC.
further time to
Yes,
file your
yes,
reply?
yes.
We'll grant you 1 week's time. We'll keep it after 1. Learned counsel for the appellant seeks an adjournment on the ground of absence of counsel. For sub next para, learned counsel for the respondents seeks an adjournment on the ground of absence of counsel. Full stop. Learned counsel for the appellant seeks an extension of the time to file affidavit in reply. Full stop. The time for filing affidavit in opposition is extended till tomorrow. Full stop. The reply thereto, comma, if any, comma, shall be filed within a week thereafter. Full stop. The application shall next be listed for hearing on July 9, 2025. 9th July. You are also SS Banerjee, so you can also appear in this.
Yes.
Shiv Shankar and Shuddha Sattva. Both are SS Banerjees.
Oh no.
You are in a different matter.
No, this matter.
In this matter, man.
He is also SS Banerjee.
Shiv Shankar Banerjee is on behalf of the respondent, man. He is for the appellant.
Other SS is not there. Let us come back. Yes. Meghnad Babu, Shuddha Sattva, Meghnad, Shuddha Sattva namta rakho. Yes. You are for the respondent, right?
Lossi, I am applying with the appellant.
Yes, Mr. Das.
Last occasion, Lossi, my knowledge.
2G. So why shouldn't you dismiss the appeal?
Yeah, 2G is not came into this case. Lossi, kindly kindly come to the.
It's not a 2G case.
No 2G. Lossi, kindly come to first plaint, which was filed by my knowledge.
Yes.
Prayer, Lossi, prayer.
Mr. Das, when did the amendment 2G come in?
2001.
2001. So it was before the demise, before the death.
No.
Before the death of the original tenant.
Original tenant died long ago. 1983. I placed this.
1983.
Yes, Lossi.
You are his heirs.
I am the legal heirs.
So then you have the Supreme Court judgment.
Thereafter, in the year of 2016, they filed an eviction suit against my client. That suit was dismissed as withdrawn. Liberty to file a press.
So then 2G does not apply because of the recent judgment of the Supreme Court.
Yes. In this plane also, there are.
Arguably, you have asked for stay of eviction.
Yes, stay was granted lawsuit. Thereafter, file an opposition regarding occupational charges. I made a reply to that extent.
We'll decide the occupation charges right now. Then we'll not dismiss the appeal because he has an arguable case. Definitely a very good arguable case. Yes, what is the extent of the premises? We'll hear him first on the occupation charges so that you can discuss. Yes.
My submission is that the tenancy is in a commercial area, ground floor, according to my
Girish Park.
No, it's just behind the Tontonia Kalibari, and it's so
police station Girish Park.
Police station Girish Park.
Behind Tontonia Kalibari, all right.
Yes.
Behind me, it's
on this way, and your lordship knows that this is entire. This is an iron.
Behind Tontonia, I have never seen behind Tontonia.
Actually, Muktaram Babu Street. From there, lordship make an entry. All those are very small lanes. Now
is it commercially viable? Although the area Girish Park strikes
entirely the iron dealers and all these things as
scraps
and all these things. So I can.
They are using it commercially also. No, they are using residential.
It's a residential.
Iron dealers are all on the main road.
Main road, yes, they can use it as a go down mallet, and there is very demand of all these things. They are after your lordships, whatever your lordship.
So what according to you is the occupation charge payable?
15,000 at least, my lord.
What is the rent? Last rent paid?
Last rent is 60 rupees, not even paid that for last 2000 probably since 2001, as I have been told.
Have you produced any comparable rent receipt in that area?
That I have not been able to.
Yes, what do you say?
Yes, lordship. That's
iron area.
No, that was situated in the gully, last part of the gully, lordship, and entire building residential purpose. Plaintiff also residing in that building, first floor and second floor.
Most of the catches come to the gully.
Lordship, thereafter, lordship, though I am not annexing that document, I stated the fact, lordship.
What do you annex? They have not annexed anything. You have annexed any comparable rent receipt there? Your own rent is 60. That you can cite.
Rent receipt in the main road, in the one room, rent was 1100 to 1200. One room. My tenancy is
where is that? You have annexed something?
I stated the statement, paragraph 6, but document was not annexed, lordship.
Document is not annexed. It may be your imagination.
No, I handed over the original document also.
No, you had to annex it.
Lordship, that due to mistake.
But
Lordship.
what 1100?
1100, 1200. Regarding two documents, I say. Regarding one, my tenancy is 2 room.
So it has to be double 1100.
Double.
লোকেশনটা গিরিশ পার্কের উপরে সব স্ক্যাপ আয়রনের দোকানগুলো লাইন তার সঙ্গে এটা কম্পারেবল না এটা একটা পেছন দিকে ব্লাইন্ড অ্যালিতে বলছে সো ব্লাইন্ড দিকে পেছনে ওখানে স্ক্যাপ আয়রনের না
Plan do?
Plan কি করে আমার
No, the affidavit has been affirmed by a housewife. What does her husband do?
husband, no, brother and sister. Brother and sister residing the tenancy premises.
You are the wife of somebody. You have mentioned yourself to be
Yes,
wife.
yes.
What does your husband do?
আমাদের হাজবেন্ড কি করে?
Scrap iron business?
Brother is not staying, my lord. It is the married sister who is actually staying. Brother, as I have been told, my lord, is not staying here.
No, we are not concerned with the brother. What does her, what is the family income?
Husband living separately. Brother and sister
We'll increase it to 3,000. More than 20%, 20 times.
3,000 will be, my lord, in that area. It will be very difficult. In another premises which I have got a possession a few years back, right now I am getting 6,000 and more.
Give us a rent receipt.
My lord, that.
Why didn't you annex it?
My lord, the problem is that your lordship knows that today, in nowadays, my lord, because of this tenancy problem, the rent receipts are not being given. It has been written in the backside of these things, and so that.
Why didn't you produce the backside?
Fix the problem, my lord. Now,
Backside, written on backside of whom?
so some kind of agreement, leave and license, all these things. That's because so that they cannot make this rent receipt, give to the rent control and all these things. That is the whole lot of problem. That's why on the first day I told that your lordship will not accept those things.
No, it's very difficult to
very
accept.
difficult to accept. Very difficult. Now, since they have already suffered, so they do not.
Yes, we'll have an auction somewhere between 10,000 and 3,000.
Lordship was decided. Lordship wishes.
You'll obviously agree to our decision.
My brother,
We'll make it 5,000.
Lordship,
Sounds better.
Lordship 70 years old. Nothing was done. Lordship.
70 years old is 5,000 is.
Lordship 3,000. Lordship
5,000.
Lordship, already I produced the document, one room to 1,100, 1,200. Lordship.
When was the tenancy created? That tenancy?
That was also the.
When was that tenancy created? Have you stated?
Tenancy
Might be 20 years back. That rent is continuing.
Original tenancy created in the year of 70.
1970 it was 1,100.
No, my lord, 600. That was Lordship.
600 in 1970. That is continuing.
60 rupees. 60 rupees.
60 rupees.
60. No, not yours. The other one.
That was 25. I showing that
25. The rent receipt is of 25. When was that tenancy created? Have you stated? Might have been created simultaneously with your tenancy.
No, that was not stated.
Then, so 1970, 60 rupees. You calculate what is the exchange rate now, how the money rupee has devalued.
Yes, my lord.
Calculate, we'll grant that amount.
Lordship, kindly consider only 70.
Just give us a calculation. What is the value of rupees 60? What was the value of rupees 60 comparable to today?
Yes, my lord. Lordship, kindly only one thing.
That was
70 years old, nothing can we do.
You are 75 years old. The tenancy is 55 years old. So at that point of time, 60 rupees should be something what he's asking for.
See, as per document, I submit Lordship.
No, 5,000.
Kindly consider Lordship.
We have considered.
Kindly consider Lordship.
Affidavits in opposition and reply in connection with the stay application filed today be kept on record. Full stop. The bone of contention today is what would be the occupation charges which should be imposed as condition for grant of stay of the impugned eviction decree. Full stop. Next para. Learned counsel for the plaintiff stroke respondents argues that the property should fetch at least rupees 15,000 monthly rent, comma, keeping in view the prime commercially viable area location of the same. Full stop. It is submitted that the property is situated on the rear portion of the Thontonia Kalibari within double inverted comma, a well-known temple in the area near Girish Park. Full stop. Next para. It is submitted that several people are running scrap iron business in Girish Park, and as such, comma, in the event a tenancy is given on the current date in respect of the premises, comma, it would fetch much more than rupees 15,000 per month. So next para. While controverting such submissions, comma, learned counsel for the appellant submits that the suit property comprises of 2 rooms which are situated near the end of an alley behind the main thoroughfare. Full stop. As such, comma, it is submitted that the same is not in a commercially viable location. Full stop. That apart, comma, keeping in view the financial condition of the appellants, comma, it is submitted that the rent of rupees 60 ought not to be increased. The last paid rent of rupees 60 ought not to be increased. Full stop. Learned counsel further submits that in the same area, comma, 1 room has been given let out for the monthly rent of around rupees 1100 hyphen 1200 per 1200. Full stop. Next para. However, comma, considering the submission of parties, comma, we find that a balance has to be struck between the current market rent which can be fetched and the rate at which the rent was being paid by the appellant last. Full stop. We are apprised that the tenancy of the appellants was created long back, comma, somewhere around the year 1970. Full stop. Thus, comma, compared to the current rate of the rupee, R capital, comma, the amount of rent would be much more than rupees 60. Full stop. However, comma, also considering the fact that the location of the premises is on a back alley, comma, somewhat away from the main thoroughfare, comma, we are of the opinion that a monthly amount of rupees 5,000 would be a reasonable occupation charge to be imposed as condition of stay. Full stop. Accordingly, Can 2 of 2025 is disposed of by granting stay of operation of the impugned decree and or any execution case, comma, if levied in connection therewith, till disposal of the appeal, comma, subject to payment of monthly occupation charges to the tune of rupees 5,000 by the appellant to the respondents, comma, in the designated bank account of the respondents, comma, the particulars of which shall be furnished in writing by the learned advocate on record for the respondents to his counterpart for the appellants by day after tomorrow. Full stop. Next para. The first of such occupation charges, comma, for the month of July 2025, comma, shall be paid within on or before July 15, 2025, and thereafter, comma, the current monthly occupation charges for each succeeding month shall be paid within the 15th day of each such current month. Full stop. Next para. The arrears of occupation charges payable from the date stroke month of the impugned decree till the month of June 2025 shall be paid in 3 equal monthly installments, comma, the first of which shall be paid by July 31, 2025, and thereafter by the last day of each succeeding month. Full stop. Next para. In the event of default in payment of any of the above amounts, comma, the stay granted by us shall stand automatically vacated without further reference to the court. Full stop. The said deposits shall be subject to the final outcome of the appeal. Full stop. You are appealing for all the respondents?
Yes. Only one.
All the respondents?
Losses instead of 3 installment, 5 installment losses. Respondent area only area.
Plenty respondent both are.
Respondent 1 and 2, my lord. I'm appealing for.
They are the only respondents.
Yes.
Losses installment is instead of 3 or 5 losses.
No.
Area per loss.
No. The in view of the appearance of the plaintiff's respondents to their learned advocate, comma, service of notice of the appeal on the respondents is dispensed with. Stop. The trial court records be called for by special messenger at the cost of the appellants, comma, to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Next.
ও আজকে সেই স্পেশাল ও আপনি ও বাবা, আপনি তো সুপার ফাস্ট। তাহলে তো ঠিকই আছে। হ্যাঁ ভালো হয়েছে।
Application the injunction. But my client as a executor
Mr.
applied.
Mukherjee have not put in the Taliban and those things. There's a do that within a week. Yes. What is the application?
But I applied for grant of probate that has been dismissed. But my other two sister and brother said that I have manipulated my father. Not only manipulated, that there is some story that I asked my sister to sign for the purpose of preparing power of attorney, but ultimately they converted to will. That's ground.
That was believed by the trial court. So you have sought injunction here.
Not to transfer the property because
You put in the Taliban and whatever.
yes, kindly give me 1 week time.
1 week time. The appellant shall put in the due requisites and Talabana as reported by the office within a week from date, full stop. Appearing for the first time application.
But only thing I've been told that there is a caveat by the learned advocate. My junior went to serve copy. He said that that the client has taken back the brief. Then we served directly to the client.
But you have filed that?
Yes, Your Lordship.
Received, received.
Yes, Your Lordship. It is received.
So next para, learned counsel for the appellant submits that when a copy of the application was sought to be served on the learned advocate who had lodged a caveat on behalf of the respondents in this court, comma, the said learned advocate informed that she was no longer appearing in the matter, comma, due to which copies were served directly on the respondents. Full stop. Next para, all the respondents have been
All the
served.
respondents, Your
Full
Lordship.
stop. Next para, the affidavit of service filed to that effect today be kept on record. Full stop. It transpires therefrom that all the respondents have been duly served. Full stop. In such view of the matter, comma, since the respondents choose not to appear today, comma, we take up the application for ex parte hearing. Full stop. Can one of since the prima facie case for hearing the appeal on merits has been made out both on facts and on law, comma, we grant injunction restraining the respondents and or their men and agents from transferring, alienating, encumbering, and or creating any third party interest in respect of the suit property and stroke or changing the nature and character of the suit property till disposal of the appeal. Full stop. Next para, the appellant shall put in due requisites. Oh, Talabana, that we have already directed. Full stop. Next para, the appellant shall be the trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks. Usual order. Liberty to mention for inclusion as and when that.
As we have not deposited the requisite notice of Talabana, kindly extend that time within 1 week. We will deposit matter.
At the inception, we have said that we will put in the requisites. That is the first sentence.
1 week.
Do it by tomorrow, day after tomorrow.
Lordship. I'm grateful to Your Lordship.
You adjust with the fees from the other matters.
Lordship.
No, he will adjust, not you.
Lordship. Grateful to Your Lordship.
Contempt, yes.
No, today I'll not take much time if Your Lordship. Lord.
Hotel versus jewelry.
Yes.
Both are lucrative.
No, Lord, hotel versus
Their scale is not much
workman's
larger.
jewelry.
Yes.
No, Lord, on the last occasion, I indicated to Your Lordship from the petition and from the supplementary affidavit with along with the documents, two nature of contempt. One, my Lord, with respect to issuance of that letter asking.
Mr. Comrade, just take the mic a bit higher.
One with respect to, my Lord, the letter which said me
Yes.
vacate.
Right.
My Lord, that is one aspect of the matter. The other one is, my Lord, continuous period of disconnection of electricity. From, my Lord, the records I have demonstrated on the last occasion, the conduct of, my Lord, the respondent or, my Lord, the contemners in, my Lord, the situation is what they are trying to portray is due to the renovation work, there were part disconnections. Now, my Lord, I had indicated on the last occasion from November till March, there was continuous disconnection. Again, from 16th of March to 21st of March, there were, my Lord, continuous disruption of electricity. It is only when I came up for this honorable court that my lord electricity was
November to
restored.
March 2024.
14th of November 2024 to 4th of March 2025. That's the first span.
Next.
Lord, may I, Lord, in that case, may I, Lord, start afresh? Lord, will that be, Lord?
No, just give us the date.
Lord, the 16th of March 2025 till 21st of March 2025.
All right.
Now, Lord, in this period, in the first period, I had written to the hotel authorities for securing restoration of my connection. Lord, instead of restoring, they gave me, Lord, the same story that renovation work is going on, I cannot help.
Okay.
Now, my Lord,
And, what is the page number of that eviction notice?
my Lord.
In your reply?
No, Lord, in the
Yes, page
the
17.
Supplementary.
Supplementary, page 17.
Yes, I'm grateful.
Right. So these are the two.
These are the two aspects. Now, my Lord, on the last occasion, I have also Lord, demonstrated before your Lordship from the other correspondences also his conduct in the matter. Lord, today I'll only show two more things. Lord, one is their opposition, the manner in which they have, Lord, dealt with it. Lord, the rules of the contempt rules of a high court, Lord, and two, Lord, judgments I'll cite before your Lordship.
All right.
Lord, kindly comes to their opposition. Page 5.
Yes.
Page 5C. The said company has such and such here abided by such order, and since 2017 has not disturbed the possession of the petitioner in the suit premises or right of ingress. There is no complaint of any nature whatsoever from the petitioner. So this itself is a false statement. Lord E. As such, the company has ceased operations of the said hotel effective from 15th of August 2024. Now, thereafter, the last sentence, though hotel operations were closed, but the banquet was operational for some bookings taken earlier. The last banquet booking was till 13th of February. So, Lord, admittedly, the banquet was functional.
The banquet was adjacent to your shop.
Just, Lord, in front of that, Lord, I display the
photographs.
The photographs were there. Lord, kindly thereafter, Lord G. Agents to and from the suit premises and have also not disturbed the peaceful possession of the petitioner on the suit premises in any manner whatsoever. Again, my Lord,
G.
Lord G, the last sentence. G, the last sentence. Till date, the company has not obstructed.
Yes.
That sentence.
Ingress and egress probably.
Ingress is not my
not an issue.
Not
much of an issue.
Lord, kindly
Electricity
comes
is.
to now page 8.
Yes.
L. By a letter dated Simon, this is the explanation provided to the letter.
Yes.
The letter. By a letter dated such and such, the respondent company had put the appellant on notice about the ongoing renovation work and also about the risk and safety of the appellant employees and customers. The appellant was informed that the respondent company will not be responsible for any damage that may happen due to the ongoing renovation work. At no point of time, the respondent company had called upon the appellant to permanently vacate the suit premises. At no point of time, not then again in regress, the appellant was requested to close his operation during the period of renovation due to safety reasons. The said letter under no stretch can be said to threat of eviction. Lord, if this is the explanation coming, Lord, I have an order. In the teeth of it, I ask suo motu, I ask modification of that order. This explanation is itself a contempt. Not kindly thereafter, M. The renovation work which is being carried out under the supervision of the state authorities, the second sentence of M. Millard. State authorities and utility suppliers such as CSC had resulted in disconnection of the electricity connection in several parts of the hotel. The electricity supply of the supervisor has been regularly, barring one or two incidents. Not the amount of period the disconnection was there. Lord, can it be said, Lord, to be one or two instances? Lord, this is what is coming on affidavit from them. Lord, I do not know whether whether this kind of language can be used in a petition. N.
What is the language?
It is furthermore important to state the petitioner has been aware of the renovation from the get.
Nowadays we are
in petitions usually we don't use this. kindly turns over thereafter, my lord. Oh. With a letter dated such and such, the petitioner informed the said company that there was no electricity supply at the suit premises. Immediately thereafter, with a letter dated such and such, company responded entirely emphasizing that restoration work involves significant risks and potential hazards that could jeopardize the safety individuals and property within premises. But if this kind of explanation come on board, Lord, then there will be no Lord, sanctity of any order passed. Lord, today a developer is demolishing a premises. I am a tenant, Lord, secure an injunction order. Lord, the developer will say, Lord, you vacate the premises, else it will fall upon you. Lord, then all orders have to meet this fate. Lord, thereafter kindly comes to page 10, R. In view of the above with a letter dated such and such, the said company has sought to provide two temporary electricity
Kormokar and Mr. Mitra, we are very sorry. We have to rise today within 2 minutes because we have a special bench at 12. We'll be continuing after 2 with this.
After 2?
After 2.
Wait.
Till recess, probably that bench will be going on. We won't be sitting before recess again.
Oh, original. May I come back after 2 minutes?
37.
Come back after 2.
Yes, after 2, we'll continue with this matter only.
Wait.
We'll continue with this matter.
Code 37.
Code number, yes, 37.
Code 37, Rojit manage.
Yes,
This is manage.
that will probably go on forever, but we'll come back at 2. Thank you. Oh, sorry, 2 p.m. too. We'll continue after 2. Sorry.
PM he might have.
No. He may say that he'll be coming. You know that. We are confident.
Another day tomorrow. That's the only thing.
Yes, Mr. Karma, please continue.
But I was only showing to your lordship. I'm sorry.
Yes.
Page 8 of their opposition, my lord. I had read, my lord, paragraph number L and then M. Demonstrating the manner in which, my lord, even in opposition, they have made incorrect statements. The sequence is like this, my lord. One fine morning, I see in the newspaper that the renovation work is going on.
Take the microphone. Yeah.
But one fine morning, I find that in the newspaper that there is some kind of renovation work going on or contemplated. Lord, I write to them, Lord, that this is the order passed by this honorable court. Please abide by it. And Lord, these are the sequence. In reply to that Lord letter, Lord, they issue that Lord 27th of August order. Now, Lord, that 27th, so Lord, the statement that they had intimated us prior, Lord, that's completely incorrect. Now, my lord, kindly comes to page 9.
Yes.
Oh, with a letter dated such and such, the petitioner informed the said company that there was no electricity supply to the suit premises. My lord, that is also after, my lord, your lordship recalls 14th, my lord, electricity got disconnected. 20th, I informed to them, I shown to your lordship on the last occasion. Immediately thereafter, 21st, the said company responded emphasizing restoration work involves sufficient risk. So, my lord, no steps were taken, my lord, to seek, my lord, go for any restoration. My lord, when I came before this honorable court, if the situation for restoring the electric connection was so difficult, my lord, immediately when I came before this honorable court, the next day, my lord, electricity line was restored. So, my lord, apparently from the face of the record, their conduct was, my lord, contemptuous. The purpose was deliberate, my lord, violation of that order. My lord, kindly, my lord, comes to the last of the, my lord, this opposition. I'll show to your lordship, page 10, paragraph R. In view of the above, the video later dated such and such, my lord, this is at a stage when, my lord, I came up before this honorable court and, my lord, this thing was informed to your lordships. And your lordships, Lord, thereafter took cognizance and wanted, my lord, me to come back with a formal application. Lord, so this reply or, my lord, this course of action leads nowhere, leads to nowhere. Lord, the other aspect of the matter, my lord, Lord,
16th March reply.
Lord, again, the said company has, Lord, R, paragraph R. The said company has sought to provide 2 temporary electricity supply points to the respondents for the shop room. It is imperative to state that such measure is temporary and not of such and such. The petitioner has to incur charges such and such. Clause requested since 4th of March, the suit is getting electricity supply through temporary arrangement. This is again an incorrect statement, plot, because on 16th of March, I have indicated till 21st of March, there was again disconnection. So, this is all on the pleadings. Not last.
The dates of disconnection you have pleaded in your contempt application,
Yes,
that has not been denied.
Not that with respect to
during this
16 to 21st, that's in the reply. That's in my reply. Not, I should not indicate
14th November to 4th of March. That you have pleaded.
That I have pleaded in the petition.
This is also pleaded.
In the contempt application.
In the contempt application,
that period has not been denied.
That period, they say that 7 except few instances. Lord, I've read out for you.
Part, yes.
That part. Lord, with respect to 16th of March to 21st of March, in the supplementary as well as, Lord, the reply, I had indicated. Lord, reply I can understand.
Supplementary was after that they filed their opposition.
After composite opposition, Lord, may I take your lordship, show that particular portion of the supplementary affidavit to your lordship. Page or paragraph. Lord, kindly comes to paragraph number 6, page 15 of my supplementary affidavit.
Yes.
Lord, 6th line, it's in the middle of that paragraph. The electricity supply has been again stopped from 16th of March. And Lord, this ranged till 21st of March.
Pictures, 31st is a pictures also.
And Lord, I have also given the pictures at page 31, Lord, showing, Lord, that on 21st of March, Lord, at page 31, Lordship kindly found, Lord, 21st of March, the electricity was not there.
Your color.
So, Lord, from 16th to 21st, the statement was also made. And their reply to this is only that 7 except few instances, the electricity was never disrupted.
You're dealing with the supplementary evidence paragraph 10, which is near denial.
And it's only a denial, my lord, at paragraph number 18 of their opposition. They say it is denied that the electricity supply had been stopped from 16th of March. That's the only denial. Lord, on the last from the pleading, I find, Lord, should be germane, subject to your lordship's, Lord. Lord, kindly comes to page number 2 of the opposition. Lord, not a single contemner or alleged contemner has come forward with your lordship to even affirm this affidavit. The affidavit is being affirmed by some authorized signatory.
Not even a party.
So, Lord, there is now, Lord, kindly takes up.
Who are the alleged contemners? What is the portfolio?
Lord, they are all directors of the company because it's a company. So, Lord, the directors have to be implicated. At least one of the directors should have come, Lord, to show, Lord, some dignity and majesty to the court. They did not bother that also.
Who is this person who's signed?
Authorized signatory.
In a contempt?
He is not a party in the contempt also.
All right, yes.
Lord, kindly comes to Rule 29, Lord, of our contempt rules.
Contempt একটা
রুলসটা আছে
যেটা বাচ্চু সমরাদিত্য পালেরটা আছে contempt of court sir.
Rule 29, my lord, has kindly got it, my lord.
Yes.
The respondent or the contemner may file an affidavit showing cause and the petitioner may file a reply thereto with such time as may be directed by the court. The court may, however, in contempt proceedings, such evidence, my lord, that's a separate chapter. So, my lord, a respondent, if it's in person, or, my lord, contemner, if it's not in person. Else, my lord, there was no requirement for respondent or contemner to be used in this rule.
Here it's the financial controller of the company.
And the person who has affirmed is someone claiming to be the financial, my lord, neither here nor there. Lord, in a similar, my lord, case, my lord, this honorable court, my lord, has deprecated this practice. Lord, may I? May I, my lord, this passed by, although, my lord, honorable single judge, Lord,
no, this is well known. This is well known. Unless the contemner files an application,
this is although not in contempt, it's in writ petition. This judgment was passed in writ petition. Lord, it has been held. The petition is utterly incompetent and this whole thing has been a complete waste of time. The first paragraph, such and such, I authorize signatory of the such and such. Ordinarily, it is only the deponent of an affidavit who can affirm the same on his behalf. A guardian or next friend minus such and such.
But even Order 29 Rule 1 of the code, we suppose that is also there, Order 29 Rule 1.
Fine.
If it's a corporation, I mean, meaning a company also. Let us just check up Order 29. All this in connection with a suit.
This is
but writ rules provide, contempt rules also provide that where the gap,
so,
the CPC will
Lord,
appear.
in the same, Lord,
Same principle,
those
yes.
principles must follow. Lord, it's in suits or by against corporation,
Yes,
any
yes.
pleading may be signed the director or other principal officer of the corporation.
Right.
So, Lord, when directors are direct parties,
No, it's a contempt then.
Contempt proceeding.
Anyway, we will hear
No
Mr.
cognizance. I say, my lord, in such situation, this opposition itself is incompetent and no cognizance can be taken thereof.
Hmm.
Not the other my last two submissions, my lord, that my lord, in contempt jurisdiction, my lord, situations cannot be circumvented. You cannot show other frivolous reasons to bypass, my lord, the act of contempt that you have already committed.
No, they may take up as a defense that they had no other option but to do it. I mean, under compelling circumstances, that may be a defense.
So that's itself is again a contempt in itself. That's exactly what
Depends
they have
on the
written.
circumstances. Depends
That's
on the
exactly what they have written. Lord, they could have come up before this honorable court. Now,
Yes,
after
that we
filing
may.
this contempt, now they have come up with a modification application. So, my lord, the intention of the contemners were, well, it's evident. Now, my lord, kindly, this only formal, my lordship knows, my lord, by heart these judgments. Eta dena 96-1. This is this is 1996, my lord, volume 1, Supreme Court cases 119. তোমাদের একটা কপি আছে এটা কোনটা এটা কোনটা হ্যাঁ ঠিক Lord, the relevant paragraph, Lord, is paragraph number 16. So far as in, I'm sorry.
Yes.
So far as orders, so far addition of words in this consent order is subject to the orders passed by such and such in such and such as concerned, we think that it was a clever ploy by the persons issuing the consent. Firstly, the order of this court dated, the factual background is of this matter is, Lord, there was a restriction order passed for, Lord, taking consent from Pollution Control Board for a particular activity. Now, Lord, the consent was given in the teeth of that injunction, Lord, circumventing, Lord, the effect of, Lord, the order. That was the background of this case. In that background, Lord, paragraph number 16. Firstly, the order of this court that is a precluded grant of any consent subsequent to such and such. Secondly, there was no point in saying that the said consent was subject to the orders passed by the Honorable Supreme Court, when the consent being granted was itself in plain contravention of the order of this court. If really the Pollution Control Board meant what it now says, the least and probably the only course open to it could have been done to apply to this court for permission to issue a consent for the reasons stated by it. It did nothing of that sort. It went ahead and issued a consent with the said misleading words, allowing the industry to operate contrary to the orders of this court. Yet another fact to be noticed in this behalf is the variance between the grounds stated in such application and the terms subject to these are subsequent. Same courts have been adopted. They could have come, applied before this honorable court. They did not. They took it upon themselves because they thought, whatever reasons, they could do that. The other aspect is misunderstanding or self-understanding of an order cannot be a defense. But that's exactly what they are trying to do. Now, this is 2009, volume 4, Supreme Court cases 213. Relevant paragraphs are 6 and 6. I'll take your lordship, Lord. Just an observation, Lord. Judgment is not that lengthy, but Lord, previous judgment is being upheld here.
Para 6, yes.
Para 6, Lord, kindly directly comes to Lord. Judgment is quoted of Lord 2006 5 SCC page 1. Lord, kindly comes to page 217.
Yes.
In such and such, this court held that the Contempt of Courts Act has been introduced in the statute book for securing confidence of people in the administration of justice. in an order passed by a competent court is clear and unambiguous and not capable of more than one interpretation, disobedience or breach of such order would amount to contempt of court. There can be no laxity in such a situation because otherwise the court's orders would become the subject of mockery. Misunderstanding or own understanding of the court's order would not be a permissible defense. And this was sanctioned, this was held, in 2002, volume 4 SCC, page 21, and upheld, again followed here. So, to sum up, I was enjoying an order of injunction. They did not challenge that anywhere. They accepted that. After continuing with that injunction for substantive time, suddenly one fine morning I come to know that renovations are being carried out. Now, I write to them out of my own volition just to remind them of this order so that because of this renovation, I don't suffer or they don't fall in contempt. Instead of adhering to that order, they issue that notice. And subsequently, in the garb of renovation, they disconnect my electricity. They say, this was required for the purpose of renovation. And immediately when I approached this court, it was so difficult to restore the electricity that next day the electricity is restored. So, all this gamut, if held together, clearly indicates their belligerence towards the court's administration of justice.
Great. Yes, Mr. Mitra.
The first thing I think I should reply is that the affidavit in opposition is not affirmed by the directors now and is affirmed by the opposition which is here, my lord. It is affirmed by the financial controller.
Yes.
Yes. I think this is the first thing which then otherwise there would be no opposition in the record. Now, my lord, in the contempt proceeding, these rules which have been shown to your lordship, there are two layers. Today, we are in the first layer where court is yet to hold whether it's a contempt or not a contempt. Now, at this stage, there is a round of affidavit. Now, after the order passed, depending on the order which is passed in the first round of affidavit, after the hearing, then, my lord, the rules is issued. Rule is, and thereafter also, against every contemner, then after the contemner gets the opportunity to answer to the rule. In answer to the rule, it is mandatory that every contemner will have to give individual affidavit. You cannot club also one affidavit, 5 cannot club in. So there are two stages. One is this stage which we are on now, and the second, answer to the rule. Rule 29 and whatever the other rules are, it holds that there are contemners at this stage. But this is I'm not saying that whether the director have not done it. If my lord's pleasure, one of the directors will definitely do it. But it is not in terms of the rules that I'm not at absolute fault. That if it is in the second stage, if I'm hold that I'm in contempt, then I become a contemner. Then I have to give affidavit the individual persons. At this stage, my lord, when we are still in the process that whether there is at all a contempt or not. At this stage, I say, my lord, the financial controller has given this affidavit. This is obviously, if my lord wants affidavit from one of the directors, will definitely come, that affidavit. Now on the point of, there are two allegations against me with regard to contempt. The first is, I have disconnected electricity. And second is, I have told the defendant or the appellant before the court, my lord, to vacate the property. These are the two basic grounds which I am facing in contempt. Now, my lordship will kindly see the appeal court, the first court order, which is at lordship in the opposition. Because I have annexed all the letters in the opposition at chronologically. It will be convenient for my lord. Page of my opposition to contempt, my lord. Page 20, Justice Bhattacharya and Justice Saraf's order.
One second. Yes.
The defendant responds.
What is it? Which is this page?
Page 20.
Yes.
The defendant respondent.
This is the order under.
It is order under.
Yes, yes.
From disturbing the possession of the plaintiff appellant in the suit premises and the right of the plaintiff's ingress egress through the common passage to and from the suit premises till disposal of the application. This application is still pending, be that as it may. So there are two parts of this injunction. I should not disturb his possession, and secondly, I should not affect his ingress egress in the property. Now, so for the second part is concerned, ingress egress, there is no complaint of this ingress egress. I am disturbing or stopping his ingress egress. There is no complaint. Now, with regard to disturbing the possession, for disturbing the possession, there are two allegations. Once again, we come back: electricity, and I told you to vacate. Now, so far electricity is concerned, I'll hit that first. I said that there was never a disconnection. There was never an intentional, willful, deliberate disconnection. Yes, I said for 1 or 2 days, the electricity was snapped because the transformer was relocated. I'll take you through the pleadings. The transformer was relocated. We had a high tension line there of 1500 kilowatt. It has been reduced to only 700 or 750 odd. And the air condition of the entire premises, because this shop is not in the arcade. Because the order of the division bench, Justice Bakshi, which was shown to you, that was for the arcade, the hawkers, because we have to renovate the arcade also. So this shop, once we enter into the hotel through the lobby, this shop is on the left-hand side. The shop in question, inside the lobby, inside the main hall room of the shop. Now, so that order, so today, my lord, I have, though the running air condition is not working. Now, I said on the day when the special officers went that there is electricity. Lordship will kindly see my lord's order at page 34. When the main allegation was made that there is no electricity. Page 34 is the order. Learned counsel for the appellant in the contempt application alleges in the teeth of the order restraint from disturbing the possession of the appellant in respect of suit premises, ingress egress to the common passage till disposal. The alleged contemners are violating such order by disconnecting electricity supply to the suit premises, thereby disturbing the possession of the petitioner. Counsel for the petitioner also seeks to hand over photographs indicating that the lounge of the respondent's hotel is at present enjoying electricity. Such contention are controverted. For the alleged contemner who contends that to the contrary to the allegations of the petitioner is at present enjoying electricity from 2 points at the premises. It is further submitted that in view of the ongoing renovation of the Grand Hotel, which houses the suit premises, in one of its portion, the electricity in general suit premises has been truncated. Moreover, it is alleged by the petitioner is no longer having any business currently in view of the entrance of the building of the hotel, and consequently to the suit premises shop is blocked due to construction. Because I said the only customers to his property are my guests. You cannot have somebody walking in the street going into your shop. Then, be that as it may, is my lord's order. The learned counsel for both the sides agree for appointment of special officer immediately to ascertain whether there is existing electricity connection in the suit premises. Accordingly, we appoint the advocate on record of both sides, named such and such, as joint special officers to immediately visit the locale and ascertain whether the suit premises is having any operational electricity connection. The remuneration, the matter is to be taken up on the next day. Thereafter, my lord, the order is at next page 37. The very next day, the officers come back. First para, I'm not reading because one of the officers was not there. The second para. Ms. Shah, one of the joint special officers, submits upon inspection. It is found that there was live electricity connection at the disputed premises. Such contention is not opposed by the learned advocate appearing for the petitioner. As such, we find that there is prima facie no contempt on the count of disturbing the physical possession of the petitioner by disconnecting electricity at the present moment. However, learned counsel for the petitioner further argues that it will be evident from the, so this part is the electricity portion. Then, my lord, comes in the other portion with regard to my letter at 21st November, which is the next. Because in that letter, I had asked to vacate the suit premises, and thereby, now Lordship has recorded my submission also, paragraph 5. For the alleged contempt now opposes to such contention and submits that it is to be looked into whether the request to vacate was made for a temporary period in view of the renovation work going in the building. Be that as it may, we grant the petition to file a supplementary affidavit. Now the supplementary affidavit comes in. In the supplementary affidavit, my lord, there is an allegation made now. In the supplementary affidavit, which is filed, my lord, in paragraph 6 of the supplementary affidavit, there is one allegation. This is on electricity. I am on electricity now. One allegation, my lord, because this order was passed by my lord at page 37, which is on 30th of April. Supplementary affidavit is affirmed on 15th of May. Now he says, electricity supply has again been stopped from 16th of March, in the middle of paragraph 6, despite electric connection. Now this is a statement made in oath. Now I have denied this. So there is a positive statement along with a denial. Now this is immediately after my lord's order. My lord's order was recorded. This order, this is of 30th of April. Now this says it was again stopped from 16th of March. Now there is no letter in support of electricity. Special officers went and found there is electricity, live electricity on 30th of April. From 30th of April till date. Now, if I disconnect the electricity, the first reaction should be a letter or an email that today morning at the says there is no electricity. There is nothing annexed. Now, I never said that I have disconnected electricity. I said because of that transformer relocation and other things, for 1 or 2 days, you did not get electricity. And I have restored it, and from that date, when the special officers went to check, it is not that I restored electricity. They went, that the submission was made, I restored immediately. It was so easy to restore. No. They were enjoying electricity. It can be only 1 or 2 days, which was beyond my control. Now, there is no letter thereafter which is coming or an email that any time from the last order of my lord was 30th of April till date, today we are on the end of June. The single instance that there is no electricity in the premises. So I say on that count, my lord, so far electricity is concerned, yes, electricity is part of their right to get because they are remaining in possession. I cannot disturb the electricity, but it is not that. Even if for those 2 days the electricity was not there, it was not deliberate, intentional, or a contumacious violation of the order under contempt. It was under a compelling circumstances, under the situations prevailing over there, which for 2 days, electricity could not be supplied to them, if I put it in this way. So this is on electricity. Now, after 30th April, there is no allegation of further disconnection of electricity. There is no letter on record. So this is my submission on electricity. Now on those 2 letters, which I said you vacate, those 2 letters are in the teeth of the order of injunction. Now, Lordship will kindly see the letter. This is once again annexed to my opposition. One letter is referred to in my lord's order only, which is at page 27 of my opposition. Yes. Because, yes, my lord, Lordship, in court, Lordship will recall that matter happened at around pre-lunch in court number 16, I remember. And Lordship has sent the special officers immediately. The special officers went during the lunchtime only. And the matter was kept on the next day. Now, page 27 is the letter which is also referred to in my lord's order at that I said that you vacate. I'll just place that letter once, my lord, because the first para was not placed. But you have been occupying the premises in the hotel illegally after the leave-in license has expired. A suit for eviction is now pending before the learned court. This is my suit for eviction. Now the next, the management of the hotel has decided to restore and conserve the entire hotel, for which purpose it has closed down the operation of the hotel from 15th of August 2024. Since you are occupying the space within the hotel premises, you are put on notice of the said fact. And it is our request to you for shutting down your shop during the period of renovation, which will kindly mark. We requested him to shut down his business for during the period of renovation. Then it continues, and or refurbishment period, in as much as there is a risk of safety and security, not only to you, but also to your customers. So a reason was given, Madam. And the period, I have not said you go and vacate it for good. It is for the period of renovation, and for the reason is, it goes for your safety and security of you and your customers. Next, we shall not take any responsibility whatsoever if any damage of any nature is caused either to men or materials inside your space or during the egress of the premises. You enter the hotel at your sole risk and peril. Then the next para which was placed, please vacate. So in this, the second para qualifies that the period I said, and why did I say? It is not in violation of the order. It is not a deliberate act to overreach the order. It can be said that you are indirect, with order said is ingress egress, you say get out. So it is becoming overreaching the order in a roundabout way. It is a contempt, I admit. Overreaching the order in a roundabout way is a contempt. It may not be always direct. I admit this. So it is not that I say you vacate for a tenanted eviction. It is for the period of renovation and for your safety. This is one letter I issued. The second letter, which is also shown to your lordship, is page 28. This letter, the first letter went in August. The second letter went in November. The second letter. Now I'll also show this letter. They have removed their furniture because they also know, because construction building materials may fall, anything can happen. Now, the page 28. We acknowledge the letter, Malad, is without electricity, that the second para. In this regard, we would like to invite your attention by our letter of 27th of August. Hereby, we informed you that Oberoi Grand Hotel, Kolkata has ceased to be in operation with effect from 15th of August. We undertake extensive renovation and conservation work. We were made to aware, you were made to aware of the situation and were requested to suspend operation of your store and vacate the premises during this period. So that's the same stand. It is because during this period. Now, it is also said that the second next paragraph, we explicitly, in our communication, we emphasize the restoration work involves significant risk, potential hazard that could jeopardize the safety of individuals and property within the premises. We explicitly stated that we would not be responsible for any incidents arising during this period. The risk is inherent to the ongoing renovation work. So, and then it continues with the renovation work, and there, because this is in November 2024. Thereafter, we said that I admit that for 1 or 2 days there maybe we failed to give them electricity. Now, I have annexed, my lord, after this first letter, my lord, chobi gulo kothay? I will kindly come to page 30. There are photographs. I don't know. We have a black and white photograph. I don't know with what's.
No, we have
whatever.
We have colored.
Now, my lord, this lordship will find at page 30. They are stacked all the materials for removal. Now, lordship will kindly turn over. Their truck is here at page 31 for removing the materials. And আরেকটা ছবি ছিল যে এখনকার যেটা স্পেশাল অফিসার তুলেছিল, and when the special of ছবিগুলো দাও, and when the special officers went, my lord, lordship has given them a liberty to take photographs also when the special officers went, because this is recorded in the order. Page 40 কোথায় আছে? Yes, page 40 is the
photographs which the special officers have taken, color photographs chilo. Now, Lordship will see the shop is vacant. They are in possession. They are in possession. Yes, obviously, hotel is closed. So there is no, I don't have a customer. My customers are there, his customers also. So is not that the lights are on in the shop in page 40 and there is no business, what I mean to say. Is not that across the counter is coming. The customers are coming, buying and selling. Business across the counter is going on because it cannot go on. I'm not disturbing his possession. I'm not disturbing his ingress egress. I only said kindly, and he is in possession. It's not that I have locked his shop room. It is under my possession. The entire the shelf and everything has been removed. No, that's not the case. The nobody's allegation. It is under their possession. They are enjoying it and they are putting on lights. And
page number 20.
They also aware of this. So I say you vacate the premises during the period of renovation, which is necessary for safety and security of your men, customers who will be coming in the premises. And they were well aware. And one more letter, my lord, which at page number 21 of my opposition, my lord, which they say, they say that the shop, the hotel will remain closed. Page 21, they issued it later in August. At page 22, when they communicate me of this order, page 22, they also say in the last paragraph, we are also looking forward to the renovated Oberoi gracing the heart of the city. So they also look forward that a modern hotel will come in, keeping up the facade intact, whatever we are doing, my lord. So they are evident. Now, today, the special officers have taken other photographs. I can show the photographs, my lord, when the special officers went. The photographs which are next here are old photographs when some banquets and other things were in operation. Today, my lord, everything has been, the floor, the ceiling, the plasters, everything has been taken out. So it is nothing inside the hotel. We are renovating it in that extent because the hotel will be remaining closed for next 1 year. So in this background, my lord, I say, first is that I'm putting it, even if for 1 or 2 days, which is beyond my control, if I have, now, I had a cheating, sorry, my lord. Page 26 is a letter which, from the CAC, which regard to that high tension line and removal of, which has come down. The high voltage bulk electricity, which has come down, which is from 1400 kVA to 750 kVA. So air condition is no more possible because I said that is through the main duct. They removed it. Now today, I repeat myself, for 1 or 2 days, there was no electricity. We could not provide them because when we were dismantling the duct and the other line, it was snapped for 1 or 2 days, but it is restored. Even if for 1 or 2 days, if my lords is minded that we have violated the order, we have disturbed their possession for 1 or 2 days. But then also, my lord, if I put it the extent for purging the contempt, to that extent, my lord, we have taken all necessary steps to purge the contempt immediately and have given electricity for 1 or 2 days. Even alternatively, I am saying it is done for situations beyond our control. It is not at all a willful, deliberate, contumacious. So I have the electricity is now there. So far, vacate the premises is concerned. In the backdrop, once again, my lord, we have never said that you vacate it for all times to come as an eviction proceeding. We said that for this period, you please vacate it for safety and security only for the period of renovation. And you, after understanding the gravity of the situation and the problem, you have removed your furniture and fixtures. So, and you are in possession of the premises. It is not that you are not in possession of the premises. I have thrown you out of the premises. Now, these are my answers to the...
Mr. Mitra, did you ever take any leave from the court? Because there was an order of the court not to disturb their possession.
I'll tell you one.
Before renovation or whatever.
My application Can 2 was filed prior to the contempt. My can 2 is pending, my lord. My application for modification of the order under contempt is filed prior to the contempt.
When did you file it?
My lord. Can 2 was filed, is affirmed on sometimes in March. Dekho copy ta dekho.
So that was much later than your notice to them to vacate. Notice was 27th of August, first notice.
Yes, that's.
So the act of contempt is not dependent on their application being filed. You gave a notice to them to vacate August 27th, 2024 in the teeth of this order of the division bench that you cannot disturb their possession. Now,
Yes.
in the teeth of that order, if there is an order restraining you from disturbing their possession, you don't take any leave of the court. You merely carry on with your renovation. Very well, go on, and even if they welcome, even without their welcoming, you can always renovate your hotel. What prevented you from taking out a simple application for leave before asking them to vacate in August 2024?
I cannot reason to this, my lord, because the only answer I can say from the client's point of view is a mistake. It's a mistake from the client's point of view. I bow down to that, my lord. It's a mistake, number one. And number two, I say the present set of advocate on records have been, there was initially the solicitor firm of this who was handling it. So, and it came back to this set of advocate on record and us much later. So the first thing which came to me, my lord, I said that whatever we have done.
So, Mitru, we are never doubting the good intentions of counsel.
No,
It's
that's
about your clients.
that's a mistake. I cannot.
Even in the 4th March 2025, page 32 of your opposition, that letter, you admit that it is impossible for you to restore their existing electricity supply beyond your control because of your own doing, because you have started renovation work. But that renovation work, prior to that, no leave was taken from court. There was an order, you knew about the order, it was passed in your presence. You cannot disturb their possession, not that you cannot dispossess them. There's a difference between the two. Disturbing possession is dispossession.
Yes.
If it was not, you cannot dispossess them, we still could have understood regarding the electricity. But once it is said you cannot disturb their possession as it was on that date. Now you admit in your letter dated 4th March that even today, I mean, even on 4th March, it is impossible for you to restore their existing electricity supply. So 2 temporary electricity supply points were given to the shop. We completely understand, Mr. Mitru, your disability because of your current renovation work. But you only grow aware after this contempt application is filed that, I mean, yes, not before the contempt application. In fact, prior to that, you restored 2 points. But that is disturbing their possession also. If suppose this electricity connection is disrupted, there was an order of some court, of this court, suppose, that you cannot disturb the possession. You take away all the electricity points for whatever reason, without leave of court. And you restore back everything, only 2 points,
Only
2 light
2
points.
60 watt points.
2 60 watt points.
point,
I mean, what
Ballard,
will be, I mean, that is, why should that not be constituted to be a palpable violation of the order of the court? This is disrupting possession. If this is not disturbing possession, what else is? I take away your electricity connection. I seal your window from the outside. I break your washroom.
in a roundabout way. You disturb.
Precisely, Mr. Mitru.
Precisely. In what's possible.
Precisely.
Because
And your directors, none of them even cared to, very well, we are not on Rule 29 also. But even if you take the basic principle of Order 29, some director of the company, you take it so nonchalantly.
No, it's not that.
That one of the, whatever financial auditors or somebody, the directors are so great that unless a rule is issued, they
not
won't
that.
personally will ensure that a rule is issued, Mr. Mitro. If that is your argument, you will record your argument. And will ensure that we invite the directors to file their personal affidavits in opposition. And if a rule is issued, Mr. Mitro, you know the language of the rule. They have to be personally present in court. And will definitely issue a rule to ensure that these alleged contemptors individually file oppositions to the contempt application, to the rule, if not to the contempt application. You could have avoided this if even one of your directors had filed an opposition. We take serious exception to this argument, not to this argument, to this attitude of your directors that yes, a financial auditor can do it. This is contempt. This is not something against the company in its juristic entity capacity. It's personally against the directors because they are the limbs of the company. The contempt is against the directors. A company is not a living being. The directors send some minion in your office
I'll tell him.
and ask him, go and file an affidavit. Now they'll come personally and explain to the court. And definitely they'll have to file show cause affidavits to the contempt application. Let us see their faces, how big they are, how large they are, how strong they are. Let us test that. Let the court test that, Mr. Mitra.
No, it's not.
If you choose to
Well, I'm very-
explore this avenue,
I'm very sorry.
let us take you to a cul-de-sac.
No, it can't be. It
Because
can
the
be
avenue
bigger.
will
It can
become a
cannot-
cul-de-sac for you, a blind alley.
It cannot be bigger than the court's dignity. It cannot be under, not even
Rule of
purpose.
law, rule of law.
Yes,
Basically,
rule of
Mr.
law.
Mitra, the judges sitting here are nothing, you are nothing.
The institution.
Nobody
The
is
institution,
anything.
the institution.
Rule of law has to be established.
Rule of law has
And
to
if
be
this is the attitude of your directors, and
No,
if you advance this argument that yes, this is not a rule, we don't go by Rule 29.
No, if it
We'll
is-
ensure now that a rule is issued so that Rule 29 is complied.
I bow down to your lordship. I said,
And there is definite contempt. You send a notice asking him to vacate by saying that during the period of renovation, you'll be out.
No, I have said him to
You leave
remove-
the premises during the period of. Let us come back to that.
Lordship will kindly.
Please come back to that.
On the first point, which is passing through your mind that
Many things are passing through our mind. Let us not be on that.
financial controller has affirmed the affidavit. The financial controller has affirmed the affidavit.
Whoever. I mean, they are not on dignity of labor.
No, it is.
Might have even been somebody else higher up than your
A
director.
director who has not done it. A director should have done it.
We are alleged contemners. This is a contempt application.
A director should have done it.
We shall, and this is not against the company at all. So this person does not have any business to answer us even.
No, Lordship will kindly come
Rule
to the
29 won't apply Rule 29, but basic principles of law,
Lordship will kindly
first principles.
come to the main letter.
Please come to that page 27 of your
Page
thing.
27, my lord. Yes, my lord.
Yes. You write that a suit for this is what could be more threatening. There's an order, just keep in the back of your mind that there's an order of injunction. You cannot disturb their possession. You say in a notice, a suit for eviction is now pending before the learned court. In that context, you say the management of the hotel has decided to restore and conserve. Very good. Since you are occupying the space, you are put on notice. Our request to you for shutting down your shop during the period for the renovation, we shall not take any responsibility if any damage happens to your men and material. You shall enter the hotel premises at your sole risk. Then they cannot enter the hotel. That is ousting them from the hotel, ousting them from possession. If you cannot enter the hotel, then you are out of possession.
We have not ever stopped them from entering the
You are requested to
premises.
vacate the space occupied by a shop immediately by removing all the stocks. Until when you don't qualify that, I mean, when you say vacate the shop room, the prior paragraph you say during the period of renovation, but you don't specify any period of renovation. For an indefinite period, whenever, whatever your suite whims or your architect suite whims offered them, I mean, this is the period of renovation required, they'll be out.
No,
This is disturbing. If this is not disturbing their position, Mr. Mitra, what is? What is? We wonder. And what else could be disturbing their position? I want to renovate to vacate till we renovate. And you prefix that by saying a suit for eviction is now pending. What is the tenor of this, Mr. Mitra? This is indefensible. Your directors are obviously in contempt and will definitely issue a rule against them.
No, my lordship will kindly see the letter once again.
We have seen it time and again. Mr. Kormokar placed it twice.
No, the second paragraph, my lord, I am only on the point that.
See the first paragraph?
No. I mean, so for the period
and the third paragraph and then the second paragraph.
So for the period is concerned, my lord, they were well aware the period is 18 months. In their letter of page 21.
How can we be well aware?
No, lordship is saying the.
How can anyone be aware, well aware, Mr. Mitra, how long renovation will take? Even the masons will not be aware.
We have a timeline with the architect, how within which period they will get the
timeline of renovation is ever fulfilled by anybody. We have never seen any timeline of renovation being fulfilled by any authority. So, indefinite period, you tell them to go out. You say requested to vacate, and if you stay back, it will be at your own risk.
No, the risk is for safety and security.
Yes.
The risk is for safety.
It's not a threat. What is?
No, but we have.
It will be staying back. Court says you don't disturb their position. You say you retain your position at your own risk. Your men and materials may be at risk if you stay back. And court has said don't disturb their position. What else is contempt, Mr. Mitra?
No, I will put it in
physically throwing them out could be better contempt.
No, disturbing their position, what the order.
You are vacating, asking them to vacate, not disturb. Vacate the occupied space immediately with all stocks. So what option remained before them than to put their furniture on the truck?
No, but I'll say that they are in possession. They are in possession of the property.
They are not in contempt. Your letter, this letter is
the
itself
order
contumacious.
not to disturb their possession.
And you write a letter saying that please vacate.
But I will qualify it once again by saying that it is within the period by the.
Was there any such qualification in the order of Justice Bhattacharya and Justice Sharaf?
No.
That
There is
apart
no
from a period of
qualification.
18 months, you won't disturb.
I cannot improve on that, Malad.
How can you?
I cannot improve on
There's
that.
no scope of
Because
that.
it's not disturbing the possession. By disturbing the possession, Malad, I say that they are in possession. They are in possession of the property. I have only warned
Not
them.
only that, also not to disturb their egress and ingress. Now, in your in this 27th August letter, you say we shall not take any responsibility if any damage of any nature is caused either to men and material inside your space or during your ingress and egress to and from the said space. You tell them go out, ingress and egress. If something falls on your head, we are not responsible.
That is the reason if some jewelry or some artifacts are damaged, because
we are more concerned with the men than the jewelry and the artifacts.
Whatever. Men will go in with.
And women also, obviously.
Now, Malad, only thing, Malad, this letter was issued.
Yes.
To safeguard us that the object.
Safeguard them from you.
No. The letter was issued.
It's like local hooligans.
No, Malad, it is not
you
that.
You pay money so that for protection money against us.
No, it's not that, Malad. The letter was issued only keeping in
Just
mind.
because you were a big hotel. I mean,
not at all,
a
Malad.
chain of whatever.
That's unimportant. I'll put it in before the order of.
You're in the hospitality business, Mr. Mitru. You're not in the business of sending people to hospitals. If you stay on, it will be at your own risk, and damage of any nature may be caused to the men and material.
This is
damage of any nature to men and material.
This letter was issued keeping in mind that
some wisecrack must have issued this letter from your end.
The chief security officer.
Chief security officer.
The chief security.
As expected, he's taking care of the security of the.
The object of issuing the letter. The object of issuing the letter was not to violate the order.
We cannot read into a chief security officer's mind. Very difficult. Inscrutable minds sometimes.
No, but the tenor.
But we can read the mind of the court which passed the injunction order, which is reflected in the order itself.
But the tenor of the letter, if I may say, Malad, the tenor of the letter is
so polite. An eviction suit is pending against you. Sir, an eviction suit is pending against you. Please vacate the premises. Otherwise, if you try to have an ingress and egress, it will be at your own risk to your men and material. And you also add, this is for the period of renovation, which you do not specify. I mean, Mr. Mitru, if this is not content, what is? We'll issue a rule. We'll fulfill your wishes.
No, Lordship will. Now, Lordship, on the point, I'll just hide two decisions.
So that your directors, we have the advantage of having your directors personally and their affidavits also.
Not only on the point of that affidavit, which is affirmed by the chief financial officer. I'll just.
So not only that is the last point which you are on.
On to answer this, Malad. If I'll beseech your Lordship to grant.
You're right. Rule 29
may not apply, but even otherwise,
is contemplated only.
Even otherwise, a director should have come and filed an affidavit.
What is the business of a third person? Whichever officer he may be of the company, Mr. Mitru.
He is aware of the proceeding. He may be.
This is a contempt rule between the contemners and the court. We are directing the contemners to file affidavit in opposition. That is our direction. The alleged contemners shall file affidavits in opposition to explain to their contempt petition.
In that even, may I beseech your Lordship?
Allegation is against you, the contemners, not against the company.
Can't be. Company,
no.
The jurisdiction. Unnatural. Now, in that even, may I beseech your Lordship, only one request.
No, you have explained your stand. You are not satisfied prima facie with this vacating business.
No, vacating business, I'm not. Only on the affidavit portion.
On the affidavit, we will issue a rule.
The person affirming the affidavit.
We'll take this affidavit in
only on the person affirming the affidavit. If
that is only a comment on your attitude of the contemners, which we will record in our order.
No,
definitely.
In that, that is the reason I'm beseeching your Lordship. I'll ensure that an affidavit.
Not now, after we expressed our mind, Mr. Mitru. No, definitely not. We have expressed our mind now. It's open for all to see. No.
Now, in that event, may I cite these two decisions before the court?
Why in that event? In any event you can cite. Please cite.
No, Lordship will kindly once again look into that. We never intentionally or deliberately wanted to violate this order.
Mr. Mitra, it was an act of God that your hotel is being renovated, or a supervening impossibility that suddenly there was there was a voice from the heavens that your hotel will be renovated and you have no power over it. It was definitely deliberate. You decided to renovate your hotel.
That
a fallout of which will be that they will be ousted.
No, that is the reason.
Vacating letter.
We never intended that. My lordship will see the letter.
Stop their business. You could have taken a leave of court, Mr. Mitra. Which court would have refused you? Which court would have refused that you renovate your hotel so that their business is also.
Reason to that when I have said it's a mistake, and I have come there after, my lord. It's not that I have not.
It's not. Again, we say it's not about the council.
It is no. I'm saying the party.
Even
the party has they applied for a can to is there, my lord.
Yes, cite your judgments.
For can to is there.
Get this matter over with.
Well, in that even I'll cite the decision, man. But we cannot issue the rule, man. We cannot issue the rule.
No, we'll definitely issue rule. Nothing remains after this but to issue a rule. Nothing less will convince your clients, will convince the contenders that they should be affirming the affidavits themselves. Now we'll bind them by Rule 29, Mr. Mitra. We'll record your submission on Rule 29. We'll uphold it. And then it will be a success for you because we accept that Rule 29. It will not be a bitter, it will not be a sweet success, but
yes,
you succeed in your argument. We agree. We fully appreciate your argument that no, Rule 29 does not apply.
It is the second stage, man.
We'll give our other reasons why, even in that case, even in affidavits to a contempt application, we lay down the law on that, Mr. Mitra, if necessary.
That's
and your judgments.
Well, that is the reason, my lordship. Then lordship will, in that event, if lordship is asking for is minded of.
We are not doing anything without looking at your judgments. If the judgments convince us otherwise, we won't.
No, it's not exactly, my lord. It is 2000. No, আমি আনি ওটা তো একই বই দুটো It is 2003 দে একটা করে দে It is 2003 volume দিয়ে দাও না হ্যাঁ 2003 volume 11 SCC page 1
আমাকে একটু বলে দাও যে মাঝে মাঝে জাজমেন্ট একটু মাঝে মাঝে খারাপ হয়েছে বলে কি Yes, Mr. Mitra.
Well, it is which is kindly come to paragraph 17. It was under the contempt of Courts Act Section 3.
Right.
Section 2B of the Contempt of Court Act defines civil contempt. It means willful disobedience of any judgment, decree, direction, order, writ, or other process of a court, or willful breach of undertaking given to a court. Willful means an act or omission which is done voluntarily and intentionally and with the specific intent to do something the law forbids, or with the specific intent to fail to do something the law requires to be done. That is to say, with bad purpose, either to disobey or to disregard the law. It signifies a deliberate action done with evil intent and with a bad motive or purpose. Therefore, in order to constitute contempt, the order of the court must be of such a nature which is capable of execution by the person charged in normal circumstances. It should not require any extraordinary effort or should be dependent either wholly or in part upon an act or omission of a third party for its compliance. This has to be judged having regard to the fact and circumstances of each case. The facts mentioned above show none of this is on the facts of the case.
There was a government scheme, that's why they could not implement.
Yes. So that's the facts of the case. So here I say, my lord,
what would you say? Mr. Mitra, as we said, this is indefensible. You as a senior counsel must know that. No, make your arguments. So you say this was not willful.
I say that this is not willful. It is not, and what is it is recorded, Malak. It is not for a bad purpose.
Evil intent, not with evil intent.
Not with the evil intent and not with a bad purpose to disobey or disregard the law or the order of the court here. It is not for that purpose. So mens rea, if I.
Yes.
Now, this decision, my lord, and the second one is 2012, volume 4, SCC 307. কপি দিচ্ছিস না একটা 12/4 SCC 307. But here paragraph is the enforcement of the order, execution rules, or paragraph 30 on the principles. Because facts will always differ from one case to the other.
Paragraph 30.
Paragraph 30. It's same, the same principles. In an appropriate case where exceptional circumstances exist, the court may also resort to the provisions applicable in case of civil contempt, in case of violation, breach of undertaking, judgment, or a decree. However, before passing a final order on such application, the court must satisfy itself that there is violation of such judgment, decree, or direction, or order, and such disobedience is willful and intentional. Though in a case of execution of a decree, the executing court may not be bothered whether the disobedience of the decree is willful or not, the court is bound to execute the decree, whatever may be the consequences thereof. In a contempt proceeding, the alleged contemptor may satisfy the court that disobedience has been under some compelling circumstances, and that in situation no punishment can be awarded to him. But this is in paragraph 30, that I stress, my lord, on the compelling circumstances and that the situation and in that situation. Because the order is from 2017. From 2017 till 2025, the order under contempt is at 2017. No? The order under contempt is 2017. For 7-8 years, when the appeal remained pending in this court, there is no allegation of any disturbance, nothing. They remained in possession whether my suit is pending or my suit is not pending, the appeal is pending. They were doing business, they're running a possession. It's not that from the very next day, or I do it every 6 months interval with a bad intention to throw them out of the property, or with a bad intention to target maybe throwing out of the property in a circumstantious way to get the order of eviction or to bypass the order of the court. It is not that. For the 7 years I'm doing, every 6 months I'm doing some action in violation of the order. Any action, that no allegation. Only in 2025, the two allegations, the electricity and this letter. Now here, my lord, what I say, this is under the compelling circumstances and in that situation. And read with, my lord, paragraph 38, which says the contempt proceeding being a quasi-criminal in nature, the standard of proof required is in the same manner as in the other criminal cases. Paragraph 38. The alleged contemptor is entitled to protection of all safeguards rights which are provided in the criminal jurisprudence, including the benefit of doubt. There must be a clear-cut case of obstruction of administration of justice by a party intention to bring the matter within the ambit of the said provision. The case should not rest only on surmise and conjecture. In the case of Devabrata Bandopadhyay with the state of West Bengal, this court observed a question whether there is a contempt of the court or not is a serious one. The court is both the accuser as well as the judge for the accusation. It behoves the court to act with such a great circumspection as possible, making all allowance for error of judgment and difficulties arising from the inverted practices in court and tribunals. It is only when a clear case of contumacious conduct, not explainable otherwise, arises that the contemptor must be punished. Punishment of law of contempt is called when the lapse is deliberate in regard to one's duty and in defiance of the authority. To take the action to an unclear case is to make the law of contempt to duty of other measures, and it is not to be encouraged. Now, paragraph 39 is once again on the facts of the case. On this, my lord, I once again say the main argument of I said in the first one that there is not that I come under the 4 definitions of willful, deliberate, and with the intention to deceive. And I add it once again, my lord, even if my lord is holding, which is my lord, is not a if, my lord is holding that this letter is issued in teeth of the order of that you should not disturb. The order is issued in the teeth of non-disturbance of the order. I should not have issued this letter. And this issuance of this letter is in contempt. Now, the first is electricity. The second is this letter. Now, once again, the purging the contempt. This action, my lord, I'm not carrying that the skipper judgment, my lord, I'm not carrying that because I'm sorry, my lord.
How do you propose to purge the contempt?
Yes, because the skipper DDA Delhi.
How do you propose to do that in this case?
Yes. Now, how do I propose to the predator? It is obviously the mercy of the court, because the court can set me a guideline for purging the contempt. The court can. The court, I can, because I have to then, will have to give me time till tomorrow to come back on purging. Because Lordship is holding that I have done, if at all.
No, we'll not punish you for that. We'll issue a rule only.
No.
Rule is the first step.
No.
First serious step.
That is the second step. I know. The rule is the first step, then answer to the rule, then is the punishment. Now,
Definitely. You're entitled to show cause, and even at the show cause stage, we can be satisfied.
Then is the
and consider the question of purging also.
Yes. Now, purging can be at this stage also. Purging can be at both the stages. I'll just tell you, because I'm sorry, man, I'm not carrying those decisions. But purging can be at both the stages. It is in the second stage, man, I'll just cite decisions on that, I'm not carrying that, that it is only when the situation comes in that whether you purge the contempt or you go to jail or you pay penalty. That the
Before
fine.
doing the other two, will definitely give you an opportunity if there is any possibility.
So that is there are three options. No? The purging, one you pay penalty, and the other is you go to jail and for a civil imprisonment. Those are things in last when after the answer to the rule. Now purging, yes, purging can be murdered in this stage also. Purging can be in this stage also. That I will cite decisions on that.
Yes.
That purging can be. Now, how do I propose to purge the contempt, which fell from your lordship?
Yes.
How do I propose to purge the contempt? Now, today, my lord, this letter is issued, and I have given. It is not that physically or by any force I have dispossessed them. It is not that physically I have said that you.
No, you have just said that you may die if you stay on.
No, and
anything may happen to your men and materials. You may die if you stay on. I am not physically ousted.
But it is once again a future incident that I have contemplated and
death.
cautioned.
Death.
Cautioned.
Death is certain, but the date is not certain.
Now, once we enter into a construction site, it is always we wear some protection.
You have made it into a construction site without the leave of court in the teeth of the injunction order. That's the difficulty, Mr. Mitro. A one-line order from a court of law from this court could have been sufficient.
No,
as we told you, as fell from us, I mean, which court would refuse you renovation? No, we might have put conditions to that.
It's a mistake.
Might have put conditions to that. Might have thought of rehabilitation. Might have thought of many other. Purging could have come then, pre-purging. I mean, they would not
action before purging. Yes. Now, so far purging is concerned, Malad. So far purging is concerned, Malad. I say today, if what fell from your lordship, that how do I propose to purge the contempt? Now, how do I propose to purge the contempt, Malad? They are in possession today, Malad. This letter is issued. I can withdraw this letter, or I cannot today with letter is issued. Now, this letter, there is no other action in support of this letter on my part. This letter is a mistake on my part, on the part of the company, on the part of the directors, on the part of the issuing authority. Also, Malad. But there is no further action in support of this letter. And for 7 years, it is not the case. For 7 years, we have every alternate month disturbed his possession. We have done something to violate the order in a circumvention way. So on purging, it is always open to the court to put me on terms, to put me how the court wants me to purge it. For me, I can say, if the question is put to me to purge the content, Malad, I say, so electricity is concerned, I have restored it. If at all there was no electricity for 1 or 2 days.
2 bulbs are 60-watt bulbs probably.
No, Malad, 2 points today with this is not a 60-watt anymore. Today is that.
Today those are not available. If those were available, you would have given that.
No, the 2 points, Malad, is enough for the pay. Because you see the electricity is there. When the special officers, when the bulbs in the hanging, all bulbs are there, Malad. The 2 points are enough for 100.
The special officer need not make it so evident that she's acting on your behest. Not to become a special officer, you have to have an amount of neutrality. Let us sit. Yes. She should get the clue. Yes.
Sorry, Malad. Now, on purging. On purging, Malad, so far, the action of this issuance of this letter. Now, this letter was issued by the chief financial officer. So he is the authority who is
No,
issuing.
letter was issued by the chief security officer.
Sorry,
Chief financial has affirmed the
No, no,
affidavit.
the letter.
So these are your people, I mean. Anyway,
Yes.
let us hear Mr. Kormakar
But
on this.
only 1 minute, my lord.
Yes, yes.
So for purging
Sir,
is
you conclude your arguments now.
yes,
We are hearing you
just-
for quite
just
some
only
time.
1 minute.
On a contempt, this is sufficient.
Yes, on a, 1 minute. But on this, when the chief security officer who has issued that letter, he should not have issued that letter. He should not have issued that letter on that day, which was issued on 27th of August. He should not have issued that letter. Now purging the content, my lord, he should be then. Otherwise, if I say that he should not have issued this letter. This letter is itself not issued by any of the directors. Both the letters, my lord, which is the main
No,
letter which.
nothing has been done by the director, sir.
Yes, this letter at page 27 is issued by the chief security officer. And
on the letterhead of the hotel,
that is there. That I can. It's not his personal capacity. He's acting as the
obviously
chief security officer of the hotel. But the natural
so
person.
don't delay so much on that. We have heard
The
this.
natural person. So, on purging, my lord, I say, my lord, I will not
keep it that
disturb
in
the possession any further
Very well.
and let him enjoy the property. Let him in
You take
possession
a
of
seat,
the
let us hear. Yes, Mr. Kormakar, at the end of the day, you are still there in possession. I mean, hauling people up in court and putting them to, I mean, sending them to jail or.
Lord, in a contempt proceeding, I'm only Lord.
See, we are not on a pound of flesh in a contempt proceeding, basically. We make it very clear. Yes, there is obviously this notice to you to vacate is contempt in the teeth of the order. But see, as Mr. Mitra submitted, for so long, so many years, they have not done anything. Now, the reason behind this is they want to renovate, which you have also said we welcome. Now, renovation is welcome for your business also. Now, if vacating, if necessary, we could direct them to issue a letter, formally withdrawing that letter, or do something else on that. Electricity, they have given back whatever they can in the existing infrastructure. So, I mean, what would be the use of contempt? If you could be otherwise satisfied on some other aspect, because if the renovation is done quickly, I mean, that should help you also, your business
As far, Lord, as I understand, Lord.
Yes.
In a contempt jurisdiction.
Yes, we find there
Lord,
is
a petitioner
contempt.
is
Yes.
only a Lord postman, nothing more than that. Lord, I have placed the entire situation before my lords. Lord, it's upon my lords.
So,
Lord, to
Kormakar, if you
decide,
say
Lord,
that, if you direct them to purge the contempt by formally, I mean, we can even direct them to issue a letter of apology to you, along with that, and withdrawing that vacating letter.
whatever my lord feels, Lord, I
That is
don't
one
have
aspect
any
of the
problem
matter,
on that.
and we can ensure that we can record Mr. Mitra's submission. Even he is senior counsel for the alleged contemners, that they won't issue any such future letter, and they will ensure that they won't disturb your position without leave of court.
Lord,
without leave of court has to be there, Mr. Kormakar, even if you don't say so, because the renovation work is going on. At some point, you will have to leave for some time.
Lord, that has to be some specific period.
Specific
Lord, it
period.
cannot be like writers' building.
Therefore, my lord, no. Therefore, writers' building, their intention was never to come back, was it?
Might be not
Renovate it, make it a museum. That also not being done.
Renovated. It's
It
going
can
on
be-
for honor. It
No,
should not be like that.
No, not like that. But Mr. Kormakar, see, this is a hotel. They obviously want to run their business, and you also.
Absolutely.
So, contempt will take us ultimately nowhere, because as he rightly submitted, the evil intention may not be there. The chief security officer acting at the behest of the hotel has done this vacating, but we don't
Thereafter,
find
Lord,
any
that letter-
malice in law there.
Lord, only one thing I'll indicate, Lord, to that argument, to meet that argument, Lord.
Yes.
Lord, kindly comes to page, Lord, 28 once, rather page 29, which Lord, of their opposition. I'm so
Of the
sorry.
opposition, page
Their
29.
opposition, page 29.
Yes.
Your Lordship sees, Lord, the signatory.
Vice President, project
So, Lord,
coordination.
first
Project coordination, Vice President of the project coordination. They have many layers, Mr. Kormakar. People like us won't understand. The president, the vice president of the project coordination may not be anybody to the hotel also.
Lord, whatever, but it's Lord, under the letterhead of Grand Oberoi.
True.
It's under the letterhead of Grand
That is another person like the chief accounts officer. I mean, he is in charge of, he is the vice president of the project coordination.
But somebody has to take some responsibility, Lord, for this.
No, we
Nothing
are
more than
saying that they are in contempt. Not that there is no
But with
contempt,
respect to punishment, my lord, whatever
but
my
whether
lords
the
decide,
criminal intent was there.
Lord, I cannot even bargain or claim on punishment.
No question of
contempt. It's
bargain. You are
complete, my
just
lord.
asking your viewpoint on
Lord,
that.
absolutely, my lord, upon your lordship.
You are at the receiving end.
Lord, first of all, my lord, my business was affected not for some.
Now
period,
you
my lord.
have electricity.
Now
Now you are still in possession. You are all along in possession.
my lord.
What came in the way is that disconnection in the meantime. It's oath versus oath. The period of the disconnection is oath versus oath. Because you first wrote on 20th of November, they restored on 21st of November. Regarding electricity, did you write previously?
Yeah. Lord,
we don't find any letter from you previously. If somebody is without electricity from
yes.
you
Lord,
had written, show us that.
Now kindly takes up the
When did you first write that there is no electricity?
kindly, my lord, comes to my lord page number top.
21 of the opposition. We take first.
Page number top. Lord, grants me 1 minute's time, Lord.
Page
Yes.
21 is the first letter of the opposition.
21 of the opposition.
That is we have annexed all the correspondence.
Yes, you have.
One. This is the first letter which came from
14th August 2020.
Yes, this is the first letter.
Lord, kindly comes to page 59 once.
No, the 14th August.
59 of?
Lord, of my application. Of my application.
That is the same letter probably.
Yes. It is
14th of August. That's the
Yes, that is page 21 of their.
Hey, go and intimate them. In reply, they issue 27th August. Now, my lord, this continued. Lord, then kindly, my lord, comes to my lord, page number 61.
Yes.
This is my complaint with respect to the continuing, my lord, disruption of electricity, 20th of November. Kindly, my lord, turns to page 66. It's not that, my lord, I have straight away come to my lord. I had given them repeated, my lord, notices that I am suffering. Lord, today, Mr. Mitro, Lord, obviously, Mr. Mitro will try, Lord, in whatever way he can. Lord, it's not, and even on the first day, on 18th of February, Lord, it is submitted that before contempt was filed, Lord, they come up with an application for modification. Lord, when did they come? On 18th of February, first came up before this Honorable Court with a supplementary affidavit. Your Lordship would recall this with the same allegations. Lord, on 18th of February, my Lord indicated us to file the contempt. In the meantime, my Lord, they read this, and till 4th of March also, since 18th of February, even 2 points could not be secured. Now, this is what I'm trying to impress upon your Lordship. This conduct. Lord, now the entire load, just like the corporate structure, the entire load is being burdened on some scapegoat. Is the security officer. Lord, is it believable that the security officer will do something without the consensus of the higher management?
Definitely not.
Impossible.
Definitely not.
In such a situation, any company will say, oh, that's a mistake by a lower minion or something, lesser minion, or anybody of such sort. Lord, today for not a second, I'm saying sending somebody to jail, Lord, give me some happiness, or Lord, I will feel proud of that. It's not like that. But Lord, kindly seize their conduct also. My Lord, they have annexed, and for the same time, Lord, in the opposition, they have tried to justify. Now, my Lord, it is coming from Mr. Mitro that it's our mistake, this should not have been done. Lord, where are those statements in the opposition? Even if Lord, although my argument is this opposition need not be taken into cognizance, does not deserve any cognizance. Even then, taking into that effect, Lord, they have shown to your Lordship a photograph at page 30 of some stack, alleging that I am taking away my furniture. Lord, where are those particulars that I am standing my...
had been writing from 14th of August regarding electricity.
Yes. 14th of August, before anything, I remind them because of this.
14th August electricity. There is no electricity on
14th
August.
The problem was that
14th
of August, my Lord, I write to them that you are going for a renovation. I have come to learn from a newspaper article. It will take 18 months. We definitely embrace your such action. But
your first letter regarding electricity disconnection, Mr.
20th of November.
Is 20th of November 2024.
My Lord. Because 14th of November it was disconnected.
And 21st they restored.
21st not, they did not restore.
Achha.
Not kindly comes to their 21st November. Regarding electricity, they justify that if you don't leave, basically we shall throw you out. Or as it fell from your lordship, Lord, somebody might die. Basically like that. So 14th, it's not that Lord, we are not creating sham disputes. 14th of November, for the first time, our electricity got disconnected.
They have been stating that the specific cause of electricity disconnection has not been identified. A team was working and there is no deliberate intention behind this. I mean, at that point, because there was no contempt at that point of contempt application at that point of time, they say specific cause of electricity disconnection has not been identified. Restoration work is going on. It was already on then. So your portion might have got disconnected.
From 14th November till 18th February. Or Milord, as I indicated, Milord.
Yes, 4th of March.
4th of March. So that is what I am on.
And when was it reconnected?
Not reconnected on 4th of March. And again disconnected on 16th of March till 21st of March.
And 20th of March you write another letter.
Yes. And the photographs at 20th of March. 20th of March.
You wrote for the first time regarding electricity disconnection on 20th of November.
20th of my lord.
And there is nothing on record you say to show that it was ever restored.
No. On the contrary, 21st they come up with an explanation. Then again I write to them on 3rd of December. To that no reply. And Lord, with respect to 21st of March issue, Lord, I have already annexed the photographs, Lord, displaying, Lord, the date when it was taken. And Lord, just in front of my shop room, the electricity is existing. That also I have demonstrated with your Lordship.
Yes.
This is belligerence, Lord, to a different level. Lord, whatever judgments my learned senior friend had relied on, Lord, I would also like to rely on those judgments because of those language. Kindly see, Lord, the photographs.
It is impossible for us to restore your existing electricity supply. 4th March. Thereby admitting that it was disconnected.
Mr. Mithu, you are issuing a rule.
My lordship was on the point that
we were thinking in two minds, but
that for purging the contempt, it fell from your lordship that we can
will come at a later stage.
We can issue a letter of unconditional apology by one of the
we'll put in our order that nothing in this order shall prevent you from what should you say? Nothing. You cannot say anything. You can do whatever you like in the meantime.
I will purge the contempt at this stage, Malad.
That may add brownie points to your.
No, this is not that, man.
Literally.
I will.
But we'll issue.
I'll file an affidavit by putting on an affidavit the undertaking.
No.
And for purging the contempt on the strength of for purging the contempt that I'm withdrawing the letter unconditionally.
Electricity they did not have for so long because you say 20th of November they write for the first time.
So long. There is the difficulty is 1 or 2 days interim periods they were not there. It's not that a continuous period was not there.
No,
that is
but
the thing.
20th November they wrote. There is nothing on record to show that. Rather, on 21st November you supported that by saying that there was renovation work going on.
That period, on that time, thereafter it was restored.
On 4th of March it was restored. When you say it is impossible for us to restore between 20th November and 4th of March, there is nothing to show from your end also that we have restored. On 4th of March, you write for the first time after 20th November saying that under the circumstances, it is impossible for us to restore. Therefore, we have decided to provide you with 2 temporary electricity.
By the time it was already there. Now, the restore means the original line, which was the high tension line with the air conditioner.
You have decided to provide him with 2 you have decided on 4th of March to provide 2 electricity points,
because
which will be charged to you on monthly basis. For the first time, you say.
For energy consumption.
That
they were paying.
My lords
before 4th of March, there is nothing on record.
Nothing.
to show that you have restored it. Even the 2 points you gave for the first time on March, you thought of giving the 2 points on 4th of March.
The 4th of March is the letter by which the electricity, that by letter on record.
There's
Now,
nothing in between.
From now on that also, my lord, even if it's my lord is minding that we should not have
We'll
disconnected.
consider that at the after issuance of rules.
So Lordship will not kindly issue the rule, my lord,
No, no,
because we'll purge the contempt, my lord. Lordship has felt from your lordship that we'll purge the contempt. We'll issue an unconditional apology letter for purging the contempt. We will also issue that letter by the directors for not by these officers and all these menial stuffs. We will issue the letter from the directors of the authority.
How do you propose to compensate for them for this period?
No, that my lord will decide. I will not say, man. It's absolutely on my lord to put me on terms. How for this period is from November to March. That what is there, the period. From November to March. From March is there when lordship has
From
seen the
14th
officers.
November to 4th of March?
Yes. Even if it is there, my lord.
16th March to 21st March is a negligible period. We may ignore that. But
No, 16 March, 27 March is their allegation, my lord. There is no letter in that support of that.
That's specifically annexed, my lord.
That is oath against oath. That is oath against oath. Now on this, my lord,
what else can we do?
we have
my lord has
we can
recorded that
issue a
in my
letter
lord's order.
for because the court and the contempt, if I may say, my lord, we can issue a letter of unconditional apology. First is withdrawing my letter. Second is an apology, and undertaking that this will not be repeated, not disturbing possession vis-a-vis electricity and any other mode of possession being disturbed, including ingress, egress, electricity and any other mode. And in addition to that, if my lord is minding of any other putting me on terms,
we have to compensate that for them for the period between 14th
my lord will
November.
kindly put me on terms for that. My lord will kindly put me on terms for that period because it's November to March.
Only that.
November to March. Lord, she will put me on terms, whatever terms, my lord. I cannot, my lord. Because I have restored electricity. That period was not there. There is no document on record to show from November to March. That was 3-4 months. That 3-4 months, 4.5 months. Now for that period, my lord, today we
What
have
is the electricity charges they were paying at that point of time? We don't have any idea.
very nominal. My lord. There are documents in the appeal court. But
Just check up.
2,000, 3,000 rupees a month. 1,000, 1,100, 1,200. That was the standard. They have annexed in the contempt petition. No, we kindly see the contempt petition. They have annexed in the contempt petition. Page 50. Sorry, Malay. Page 52. Page 52 is 1,000 rupees. Page 52.
Even you take it, Mr. Gormakar, what?
There are also amounts ranging to 3,000 and odd.
No, electricity charges.
Electricity charges.
If you take an average 2,000, Mr. Kormakar, for these 5 months, at best you would have been charged rupees 10,000. So we can direct them to pay that. That won't help you.
Lord, I have
Your jewelry shop will suffer a loss of goodwill if you get only 10,000 rupees.
Lord, I have not placed the entire case before your lordship, Lord. Now it's upon my lord's conscience, Lord, whatever my lord decides.
The electricity charges are 1,000, 12.
Lord, if Lord paying this way, Lord can take away contempt, Lord, then each and every person, Lord, I don't think Lord will think twice, Lord, before committing the contempt and then come back and say sorry.
Well, I'll file an affidavit before this court enclosing the
What stopped you from filing?
apology letter.
You used an affidavit.
And I'll file an affidavit before this court, my lord.
No, if we purge it only, we have to direct that only.
And I'll file this not before the court also. I have to file an affidavit. And
the only
so
thing is,
the names of the directors.
If this line of action, Lord, is adopted, Lord, each and every person will not think twice. before committing a contempt, and then next day will come up and say, I am so sorry, please take this, my apology and everything.
No, not under normal circumstances, we'll give the reasons, Mr. Kormakar. The present contempt application has been filed on the allegation of willful and deliberate violation of the order dated order dated October 25, 2017, passed in CAN 6975 of 2017. No. Take your seat. Definitely not. Yes, Mr. Ko. 6975. Yes, Mr. Mitra, you may also go. You don't take the risk. You don't take the risk.
Take the risk.
We will change our mind midway if you go.
No.
CAN 6975 of 2017, filed in connection with FAT 391 of 2017 by a coordinate bench of this court. First of next para, the petitioner alleges that during subsistence of the said order of injunction and in the teeth of it, comma, the electricity supply to the suit premises was disconnected by the alleged contemners from November 14, 2024 till March 4, 2025, and thereafter from March 16, 2025 till March 21, 2025. First of next para, despite the petitioner having written to the alleged contemners about such disconnection, comma, the alleged contemners, comma, citing the ongoing renovation work of the hotel, comma, which is owned by the respondent number 1 in the appeal, comma, failed to restore such electricity connection, full stop, subsequently by a letter dated March 4, 2025, comma, while expressing their inability to restore the electricity supply as it originally stood, comma, the alleged contemners gave out that they would restore 2 electricity points to the suit premises. Full stop, next para. It is further alleged that not stopping there, comma, the alleged contemners issued a notice dated August 27, 2024, asking the petitioner to vacate the suit premises. Full stop. In the said letter, comma, the pendency of a suit for eviction at the behest of the respondents in the appeal was also mentioned. Full stop. It was further stated that unless the petitioner shut down its shop, comma, run and the suit premises, comma, during the period of the renovation and stroke or refurbishment, comma, there is a risk of safety and security not only for it but also its customers. Full stop. The alleged contemners gave out that they would not take any responsibility whatsoever if any damage of any nature was caused either to men and material inside the space or during the ingress and egress to and from the said space of any nature whatsoever. Full stop. It is argued that such act on the part of the alleged contemners was palpably contumacious. Full stop. Next para, further pointing out to the affidavit in opposition filed to the contempt application, comma, learned counsel for the petitioner submits that in derogation of the established practice of this court, comma, none of the alleged contemners cared to file such affidavit but delegated the said job to some employee of the respondent number 1 company in the appeal. Full stop. The said act itself, comma, it is argued, comma, shows the nonchalant attitude of the alleged contemners. Full stop. Next para, learned counsel for the petitioner cites Rule 29 of the Calcutta High Court Contempt of Court Rules 1975 to argue that in a contempt application, comma, the respondent or the contemptor has to file an affidavit. Full stop. Such affirmation cannot be relegated to some third party. Full stop. Next para, learned counsel for the petitioner next cites such and such reported at 1996 1 SCC 119, where the Honorable Supreme Court held that the alleged contemptor therein had no point in saying that the consent given in the said case was subject to the orders passed by the Supreme Court, comma, when the consent being granted was itself in plain contravention of the order of the said court. Full stop. If really the alleged contemptor meant what it said, comma, it was held, comma, it could have done. Now, what it could have done was to apply to the court for permission to issue a consent for the reasons stated by it. Full stop. Next para, it is argued that in the present case as well, comma, it was always open to the alleged contenders to file an application for modification stroke variation of the order of injunction. Full stop. Instead of taking such course, comma, the alleged contenders took the route of deliberately violating the order of the court. Full stop. Learned counsel next cite such and such reported at 2009 4 SCC 213, where it was held by the Honorable Supreme Court that if an order passed by a competent court is clear and unambiguous and not capable of more than one interpretation, comma, disobedience or breach of such order would amount to contempt of court. Full stop. There can be no laxity in such a situation because otherwise the court orders would become the subject of mockery. Full stop. Misunderstanding or own understanding of the court apostrophe S order would not be a permissible defense, comma, it was observed. Full stop. Next para. In reply, learned counsel appearing for the alleged contemptor submits that Rule 29 of the contempt rules of this court mandate that once a rule of contempt is issued, comma, it is for the alleged contemptors to file affidavits. Full stop. Since the present matter has not as yet reached that stage, comma, the alleged contemptors were under the impression that an affidavit filed by a person having knowledge of the circumstances of the case would suffice. Full stop. However, comma, learned senior counsel appearing for the alleged contemptors immediately supplements his argument by saying that if this court directs, comma, all the alleged contemptors are agreeable to file individual affidavits to that effect. Full stop. Next para, learned senior counsel next argues that the sole purpose of asking the petitioner to shift shop from the suit premises was for the purpose of renovation of the hotel run by the respondent in the appeal. Full stop. It is submitted that since the business of the petitioner is also run from inside the said hotel, comma, such renovation would also aid and help the petitioner and assist in augmenting its business. Full stop. Learned counsel, senior counsel also relies on one of the correspondences annexed to the pleadings to argue that even the petitioner expressed its appreciation of the renovation being done to the hotel. Full stop. Next para, thus, comma, it is argued that there was no malice on the part of the alleged contemptors in asking the petitioner to vacate the premises. Full stop. Such vacating, comma, it is submitted, comma, was meant only to be for the limited period during which the renovation work would be completed. Full stop. Next para, learned senior counsel further argues that the disconnection of electricity was not deliberate but was a fallout of the renovation work going on in the hotel. Full stop. It is submitted that even as per the correspondence between the parties, comma, the alleged contemners had intimated the petitioner that it had assigned a team to look after the cause for to find out the cause for the disconnection at the suit premises. First up, it is submitted that on March 4, 2025, the alleged contemners had written to the petitioner stating that in the backdrop of the renovation work going on, it would not be immediately possible to restore the electricity connection to its full, as it originally stood, to the suit premises. First up, however, to show its bona fides, the hotel had given electricity connection at 2 points of the suit premises immediately. First up, it is denied that there was any subsequent disconnection, contrary to the allegation of the petitioner. First up, thus, learned senior counsel reiterates that the respondents stroke alleged contemners ought at least to be given an opportunity to purge the contempt, if any, and to tender unconditional apology for the same. First up, it is submitted that although a notice was given to the petitioner to vacate the premises, it was not in derogation of the interim order of injunction restraining the respondents from disturbing the petitioner's possession. First up, rather, the vacating was intended for a limited period of renovation. First up, learned counsel for the respondent cites such and such reported at 2003-11 SCC 1, where the Supreme Court had observed in the context of section 2 within bracket small b of the Contempt of Courts Act, which defines within double inverted civil contempt, double inverted clause, that the term double inverted willful inverted clause means an act or omission which is done voluntarily and intentionally and with the specific intent to do something the law forbids, or with the specific intent to fail to do so, something the law requires to be done, that is to say, with bad purpose, either to disobey or to disregard the law. Full stop. It signifies a deliberate action done with evil intent or with a bad motive or purpose. Full stop. Therefore, in order to constitute contempt, the order of the court must be of such a nature which is capable of execution by the person charged in normal circumstances. Full stop. Next para. Learned senior counsel next cites such and such reported at 2012-4 SCC 307, where the Honorable Supreme Court had observed that in an appropriate case where exceptional circumstances exist, the court may resort to the provisions applicable in case of civil contempt. Full stop. However, the court must satisfy itself that there is violation of such judgment, decree, etc., and such disobedience is willful and intentional. Full stop. Next para. The benefit of doubt, as in criminal jurisprudence, should be given to the alleged contemner in such cases. Full stop. Next para. Upon a careful consideration of the arguments of parties, we find certain factors attending this case which are relevant in context. Full stop. Next para. In order to ascertain whether the deliberate intention of the alleged contemners had been to willfully and deliberately violate the order of this court, we cannot but take into consideration the fact that the said order was passed as long back as on October 25, 2017. Full stop. Next para. For the long period of 7 years thereafter, there has been no allegation whatsoever as to any attempted violation of the said order by the alleged contemners. Full stop. Next para. It is only in the month of November 2024, when for the first time, as per the petitioner's allegations, the electricity supply to the premises, suit premises was disconnected. Full stop. On March 4, 2025, the alleged contemners had responded to the concern of the petitioner regarding such disconnection by addressing the issue on the ground that due to the ongoing renovation work, comma, the electricity disruption had occurred. Full stop. Next para. However, comma, in the same breath, comma, it has been stated that a team had been assigned to find out the exact cause for such disruption. Full stop. By a letter dated March 4, 2025, comma, the respondents wrote to the petitioner stating that it was impossible for them to restore the existing electricity supply. Full stop. Such impossibility was in the backdrop of the fact that the condition of the electrical wiring and air conditioning equipment were outdated and of poor condition, comma, which was one of the key focus of the renovation work which was being done in respect of the hotel. Full stop. However, comma, to show its bona fides, comma, to show their bona fides, comma, the respondents expressed their decision to provide the petitioner with 2 temporary electricity supply points for the shop. Full stop. Next para. Upon an inspection being held on the direction of this court during pendency of the contempt application, comma, it was found that such electricity connection is still subsisting at the suit premises. Full stop. Also, comma, there is no allegation of any further disconnection after March 21, 2024. Full stop. Next para. It is patently obvious that the said disruption in electricity was due to the renovation work going on at a large scale, comma, encompassing the entire hotel, comma, including the suite premises. Full stop. Next para. We must also take note of the fact that the petitioner itself was complicit in the act of renovation going on, comma, since at no point of time did the petitioner complain regarding such renovation work. Full stop. Rather, comma, in one of its correspondences, comma, the petitioner had expressed approval to the renovation work and had welcomed it. Full stop. Next para. Seen in such background, comma, we have to admit that the disruption in electricity cannot be, comma, beyond reasonable doubt, comma, imputed to the willful intention of the alleged contemners to deliberately violate the order of this court after 7 long years of the same being passed. Full stop. We have a more serious case at hand in respect of violation of the order of the court in the letter dated August 27, 2024, which was issued by the Chief Security Officer on behalf of the Oberoi Grand, comma, Kolkata, comma, which is the hotel in question, run by the company of which the alleged contemners are, of which most of the alleged contemners are the directors. Full stop. The Chief Security Officer, comma, who is also one of the contemners, comma, had written the letter citing the risk of safety and security to the men and articles of the petitioner in the event they failed to vacate the premises immediately. Full stop. At the first blush, comma, the mention of a pending suit for eviction and the imminent threat of danger to the men and material of the petitioner, comma, as evinced from the said letter, comma, seems to be menacing and an attempt on the part of the alleged contemners to disrupt and disturb the possession of the petitioner in violation of the order of the court. Full stop. However, comma, taken in appropriate context, comma, in the second paragraph of the said letter, comma, the clear reasons cited for such notice was that the renovation work and refurbishment going on in the said hotel necessitated such letter. Full stop. It was even stated in the letter that such vacating of the premises would be temporary, comma, restricted to the period of such renovation and stroke or refurbishment, comma, which was going on without any demur from on the part of the petitioner. Full stop. Next para. Thus, comma, the issuance of the letter asking the petitioner to shift from the suit premises was absolutely temporary and could not, comma, in proper perspective be said to be to imply a definite malice or malicious intention to disrupt or violate the order of the court on the part of the alleged contemner. Full stop. Next para. As held in Ashok paper Kamgar Union Supra, comma, there has to be a within double inverted bad purpose, double inverted, or double inverted evil intent, double inverted close, or a bad motive or purpose behind the violation of the order of the court. Full stop. In the present case, comma, although the act of issuing a letter to the petitioner to vacate the premises borders on contempt, comma, we cannot castigate the alleged contemners by taking the extreme measure of penalizing the alleged contemners at the first instance. Full stop. Next para. Insofar as the argument of the alleged contemners regarding the alleged contemners having not filed any affidavit in opposition is concerned, comma, we are unable to agree with such contention of learned senior counsel for the respondent. Full stop. It is an established custom and procedure of this court and several other high courts that in a contempt proceeding, comma, any affidavit filed on behalf of the alleged contemners have to filed by them individually, comma, separately and personally. Full stop. Next para. It may be noted here that the allegations leveled in the contempt application are not against the respondent company running the hotel in question, but individually against the alleged contemners, comma, who mostly are the directors of the company or the persons instrumental in issuing the incriminating letters to the petitioner. Full stop. In the teeth of such allegation at a personal level, comma, the affirmance of the affidavit could not be delegated to some third person by the alleged contemners. Full stop. We would definitely have taken strong exception thereto unless the learned senior advocate appearing on behalf of the alleged contemners somewhat salvaged the situation by immediately offering to affirm, to have affidavits affirmed individually and personally by each of the alleged contemners, if so required by the court. Full stop. Next para. As such, comma, we find from a comprehensive appraisal of the facts on record that although the issuance of a notice to vacate the premises and the disruption of electricity is in violation of the order of this court, and the alleged contemners would be prudent if they had sought in advance a modification or a variation of the order of injunction to the effect seeking permission to renovate the property and for the time being to make alternative arrangements for the petitioner, comma, we feel that the extreme step of punishing the alleged contemners at this stage would be inappropriate without giving them an opportunity to purge the contempt. Full stop. Next para. Accordingly, comma, we direct each of the alleged contemners, comma, individually and separately of their own to affirm affidavits expressing their unqualified apology for the violation of the order of this court dated October 25, 2017, passed in FAT 391 of 2017 with CAN 6975 of 2017. Full stop. In the said affidavit, comma, each in the said affidavits, each of the alleged contemners shall also express unqualified apology for issuance of the notice dated August 27, 2024, was it? August 27, 2024, asking the petitioner to vacate the
August 27.
August 27, 2024, asking the petitioner to vacate the suit premises. First of such apology shall be directed not only towards the court but also to the petitioner. First of next para. Thirdly, in the said affidavit, the alleged contemners, individually, in each of their affidavits, shall undertake in an unqualified manner that no further notice asking the petitioner to vacate the suit premises and or any other attempt to disturb the peaceful possession of the petitioner in respect of the suit premises would be made in any manner whatsoever, subject of course, to any leave being taken from the court taking up the first appeal and or any order passed by such court. Full stop. Next para. Fourthly, the affidavits shall each contain the further undertaking that the electricity supply being provided for the present to the petitioner at the suit premises shall be sustained, also subject to any leave or order passed by the court granting permission to the alleged contemners or the respondents in the appeal to do so. Full stop. Next para. By way of compensation for the period between November 14, 2024 and March 4, 2025, during which the petitioner was without electricity, the alleged contemners shall collectively pay an amount of rupees 50,000 to the petitioner within a fortnight from date. Full stop. Next para. It is submitted that it is recorded that in the event the above actions are taken by the alleged contemners to purge the contempt, this court will consider the present contempt proceedings being dropped. Full stop. Next para. The matter shall next be listed on what will be a reasonable time. Today we are on 30th, so we'll keep it 4 weeks after. Next be listed on July 22, 2025 under the same heading for the purpose of compliance of the above directives by the alleged contemners and for passing further orders.
My lord, only thing Lordship has given us 4 weeks. Now, so far the directors are concerned, my lord. We will file. Dekhe now. They are not 6 weeks because it can be within 4 weeks. There are
We'll give you 6 weeks. We'll give you
12
6 weeks.
contemners. Majority will come within
We'll
4 weeks
give you
for
6
sure,
weeks.
but maybe 1 or 2.
No, we'll give you 6 weeks. Returnable date July 22 na kore. Thank you. August 11, 2025. August 11, 2025. First up, the affidavits directed above shall be filed on the returnable date with advance copies to the learned advocate for the petitioner. But that 50,000 you will pay within a fortnight.
I'm deeply obliged, my lord.
Thank you.
The rule would have been a bigger issue.
No, you salvage the situation for the alleged contemners.
No, the name of the contemners is the more troubling me. May not be nothing for the court, must be.
No, the name of the we continuously had to saw the names midway actually, and we are being very candid, Mr. Mitra. We constantly had to fight a reverse bias. I mean, a bias was working in our mind that let these people come and explain themselves because of the big names, so-called big names. So that was our intention. Midway,
that is affecting me also.
Yes, midway we had that urge. We were constantly battling that urge that let these people come and find out that they are also not above the law. But it was a constant battle, and we won the battle because we should be fair. I mean, why just because of their position in society, why should they be in a different position than any other person?
Deeply obliged.
Thank you. That their position was going to go against them. We constantly
For the
fought,
position.
fought that urge. That
For the position is
that also should not be. That is also not
No, no, no.
equality.
for everybody should listen.
That is also not equality.
Obligement. Grateful.
But these affidavits, Mr. Mitra, ensure that they are individually given
No, no,
by these persons, however big they may be.
Only 15 is difficult, otherwise is not. Only the
One
15
person difficulty will issue a rule and we know what to do.
15 is difficult, otherwise everybody will.
Who is 15? Everybody? 15 to
I may be missing this. Only the 15. No, this is beyond the five. Only 5 is difficult, otherwise others will eventually give.
The application thing?
Contempt.
Contempt.
Lordship has seen 5. Otherwise, they think that
If 5 will be the first to give. Take it from them.
for
Take-
we lawyers, useless, worthless.
No.
Yeah, I know, Baba.
You have saved them. We have put it in our order. You have salvaged the day.
Deeply.
5 would be the first to give the affidavit. If she does not, Mr. Mitra, courts of law know their ways. We won't be lost in a maze.
Yes. And that should be. That should be.
Suffer the wrath of court.
Yeah, that should
Take a video recording of the court's proceedings.
That should be. Yes.
Yes.
That should be. Obliged.
Yes. Next. আমি প্রথমে দেখিনি মাঝখানে দেখলাম তখন মনে হচ্ছিল সালাদের আমি আছি কিন্তু বাট
My lord, item number 13, I am for the petitioner, my lord. There's some defect. I seek before you the liberty to cure the defect and come back to
liberty
you, my
given,
lord.
move the matter.
My
Liberty
lord,
given.
As of now, let me cure the defect. That is the
No, as
instructions.
of now, you move the matter.
That is all the instructions that I have from my senior,
You're
my
not
lord.
bound by your senior's instructions. Sorry, move the matter. Where is your brief?
Kindly gives me 5 minutes so that I may
How
get
long
the
are you
brief.
practicing?
2024 pass out, my lord.
24 which month?
I got my enrollment in the month of November, my lord. November.
Sufficient time. Bring your brief and we'll passing it over.
Grateful.
Move the matter. Who is your senior?
Advocate Auditra Bhattacharya, my lord.
Very well. Come prepared in the matter. We'll give you 5-10 minutes.
Grateful.
But don't escape.
My lord, I'll be coming back. Just give me 10 minutes, my lord.
Yes. Have you removed the defects?
But there are so many major
defects.
defects, my lord. My lord, first,
We dismiss. Better to dismiss the appeal and file afresh.
my lord,
So many defects. Why do you file such defective appeals?
some appeal, my lord, I am reading.
If the appeal
some,
is so defective, let us dismiss it. Yes.
let
So
the date of judgment furnished in the respective degrees of both the
trial
courts.
judge's name is not there in the preamble. Name of the deceased appellant is not there.
My lord, third point, my lord, that which is beyond my control, my lord. The date of the judgment furnished in the respective degrees of both the courts
That will send
are
the-
wrong.
That will send the file to the court below for being corrected. That will be done later. But what about the ones within your control?
My lord, name of the trial, and this is my control.
Trial
my-
court judge
my lord,
name in the preamble.
appeal was filed by the learned advocate who died, my lord, Mr. Onadi.
You carry out the corrections, then we'll give you 2 days time.
My lord, this point can be
You
rectified.
carry out the cure the defects.
Some defects I will carry out, my lord.
Whatever you can, you carry out.
Yes, yes.
The ones for which you have to send back, that will
Yes,
do.
yes, my lord. My
Don't
lord.
worry about those.
My lord.
You have filed the certified copies of both the judgments and decrees.
Yes, yes, yes.
Both are there.
Yes.
So whatever defects you can carry out in the preamble and other things, please check up and
Yes,
carry out.
yes,
We'll take
yes.
it up. Say day after tomorrow, we'll take it.
Yes, yes, my lord.
The learned advocate for the appellant shall rectify the curable defects by tomorrow.
Yes.
Full stop. Let the matter be listed next on July 2, 2025, 2nd July.
Yes, my lord. Grateful, my
এটা
lord.
একটু সোজা করে দেবেন তো ক্যালেন্ডারটা তারে লেগে যাচ্ছে বলে একটু উপাস হাত যাবে তার হ্যাঁ তারের উপর দিয়ে গেলে আবার এক জিনিস হবে
My lord, item number 15, my lord. There is one extension that I am seeking to file the supplementary affidavit because the petitioner, the time span, if my lord asks, the petitioner is a cancer patient, my lord. There has been some problem in the coordination, but the brief is coming.
Question of his supplementary affidavit. What is your name?
Dibbo Mukherjee. Dibbo, D-I-B-Y-O.
Deep.
D-I-B-Y-O. No, not the supplementary affidavit, rather the...
Your name first.
Dibbo Mukherjee.
Dibbo Mukherjee. Mr.
Dibbo
Mukherjee.
book. The LCR rather. The LCR is not yet prepared. That is, I am extremely mistaken.
Mr. Mukherjee, this appeal is at the order 41 rule 11 stage. What is order 41 rule 11?
To prepare for the LCR, my lord.
No. Order 41 rule 11 of the Code of Civil Procedure is that the court has a hearing in a second appeal to see whether there is any substantial question of law involved. Actually, order 41 rule 11 is for first appeal. Court has to see, if the court feels that it is not required to be admitted, it dismisses it. Order 41 rule 11 says the court may dismiss the appeal at the outset. If it does not, under rule 13, order 41 rule 13, it directs notices to be served. Qualified by order 42 relates to second appeals. Order 42 says it has to be on a substantial question of law, read with section 100. So the applicability of order 41 rule 11 in a second appeal is read with order 42. That means this hearing is done by a division bench of this court to ascertain whether there is any substantial question of law involved in the appeal, right? If there is a substantial question of law involved, we hear only the appellant, not the respondent. If there is a substantial question of law involved, we admit the appeal and pass necessary directions. Up to this stage, there is no scope of any filing of affidavit. Affidavits are filed to state facts.
I was mistaken, my lord.
There is no scope of any filing of affidavit. You are seeking extension of time to file affidavit. There is no scope.
Not the affidavit, rather the LCR was to be prepared.
LCR cannot be prepared if you dismiss the appeal at the outset.
Then I'm mistaken.
Don't speak too much, Mr. Mukherjee.
I am
Listen a
mistaken.
bit.
I am
Listen a
mistaken,
bit.
my lord.
We are giving pure and simple gyan to you. So this is a pedestal. We are giving a sermon to you. Absorb the sermon, keep it in your mind, so that we don't have to give this sermon the second time. Let us hear the music first. Yes, no, it's over. So this is only an admission hearing. Unless the appeal is admitted, Mr. Mukherjee, no directions, LCR, paper book, nothing. If you dismiss the appeal right now saying there is no substantial question of law, it goes. There is no question of any LCR, nothing. So before we admit the appeal, we hear the appeal for admission. We have to find out whether there is any scope of, whether there is any defect. Can you say what is the defect here?
In item number 15, my lord, no, and I do not have access to the brief. I was just given the instruction, nothing else, but I do have the brief to the item number
You go
30.
through the brief, we'll give you 2 days time. Have you filed any application for condonation of delay? That has to be heard first.
I am not aware of, my lord. I am not aware of. The advocate on record is someone else.
On the prayer of the appellant, the matter is adjourned for the day. Come back tomorrow, you ascertain. Ask your senior to ascertain whether you have filed any section 5 application for condonation of delay. There is a delay. If you have not filed, you'll have to take steps.
Grateful,
Take
my
it up tomorrow, you come back.
Grateful.
Even if your senior is there, you also have to come back.
Grateful, my lord.
কোনটা? 13, Mr. Mukherjee, or 15 also?
13 and 15.
13 also we are passing the same direction. 13 এও তাই করে দিন, একই order হবে.
Grateful, my lord. Grateful.
Yes, next.
Item number 16, Lordship, I beg to appear for the respondent's Lordship. It is at order 41 stage, but the only injunctions that I want is, Your Lordship, the ad interim order of injunction has been vacated. We have filed an application under section 5 and 8 of the Arbitration and Conciliation Act.
Section 5 was directly.
Allowed. Yes, Lordship, kindly sees the order.
It has been allowed.
Yes, 5 and 8 allowed. Suit says.
Therefore, order 41 hearing now.
Yes, it is at order 41. I just.
What is the, just give us the points.
Lordship, this is an.
You are the plaintiff.
No. I'm for the respondent.
Ad interim was granted.
Yes, yes, yes. Ad interim order of injunction
Take
was
the microphone a bit closer,
Ad
please.
interim order of injunction was granted, Your Lordship. The appellant has preferred an appeal, challenging the order passed under Order 39, Rule 1 and 2 of the Civil Procedure Code, Your Lordship. We have subsequently filed an application under Section 5 and 8 of the Arbitration and Conciliation Act. Our application was allowed and the suit was stayed.
Suit has been sent for arbitration.
State has sent for it.
Oh. Then
Kindly produces the order itself.
with this injunction or without the injunction?
The injunction order has been vacated itself.
Has to be vacated, otherwise because Section 17 is there.
Yes, yes.
So this has become infractuous then. Very well. Learned counsel for the appellant submits that subsequent to the filing of the appeal, an application under Sections 5 and 8 of the Arbitration and Conciliation Act 1996 was filed in the trial court, which was allowed, and the suit has been relegated to arbitration. Accordingly, the appeal has been rendered infractuous. In view of such submission, affirmative 425 of 2023 is dismissed as infractuous without any orders to cost. There was no interim order. Can 1 of 2023 is also disposed. No, Can 1 was the Section 5 only.
Yes.
Can 2 of 2023 is also disposed of accordingly. Interim order, if any, stands vacated. We make it clear that we have not entered into the merits of the contentions of the parties. No orders to cost. Thank you.
I've got the appellant, my lord, led by Mr. Obhijit Basu, is appearing virtually, my lord.
What is the matter about?
My lord, I appear for the appellant, my lord.
Yes, Mr. Basu, what is the matter about?
This is a suit for eviction of a lessee in which my client was the defendant along with his wife, who is the pro forma respondent here. My lord, we had to defend ourselves in the learned trial court. We lost, and thereafter we went to the learned first appellate court, and there also we lost. Yes. Now our case has been consistently to this effect that we were premises tenant.
Right.
And the plaintiff's case was that it was a lease for 21 years. We said that we could not have looked into, first of all, none of us knew English, and otherwise we did not know the exact contents, and we had been to the registry office. We did not as such dispute our signature and in the lease deed. Now thereafter they have now come up with that suit, and the decrees are in their favor. But what I submit before your lordship is that whatever evidence that we gave here are admissible, subject to correction under Section 92, Proviso 1 of the Evidence Act. Now that part of the matter has not at all been considered. That is one ground we have.
Mr. Basu, what about this? There was a registered lease deed, you said?
There was a registered lease deed, possibly.
So yes, then it was a lease under the Transfer of Property Act.
Lease under the Transfer of Property Act as per the plaintiff, but our case is that we knew that we were getting into a premises tenancy agreement.
So your tenancy was terminated by efflux of time or 106?
Efflux of time. That they are saying in 2012 it came to an end. Thereafter they filed a suit.
So how do you defend that? I mean, your plea.
I am only saying, Lord, that Section 92 of the Evidence Act makes my evidence also admissible. So the court, while considering the
Evidence Act
only one question.
My lord, I have formulated two questions of law for your lordship's counsel.
What do you mean by Section 92 was not complied?
92 Proviso 1, your lordship will see.
Yes.
See, Lord, that normally in a oral agreement will not be taken into consideration, but there are certain exceptions. That Proviso 1 says that any fact may be proved which would invalidate any document or which would entitle any person to any decree or order relating thereto, such as fraud, intimidation, and other things. Now, in this case, we have alleged fraud And we have also, by way of filing a counterclaim, we have asked for a decree that for a declaration that we are premises tenant. That is ground 11 of my memorandum of
No,
appeal.
not that, Mr. Basu, but you failed to prove fraud, and Order 6 Rule 4 also comes in. Where is the question of the courts granting a degree on that?
No,
What proof of fraud did
saying
you
my case has not been considered at all. Your Lordship will see the judgment. I understand, Lord, that I might have lost. That is a different thing. But not considering the case at all just because there is a document is something else. When there is an admissible evidence, that has to be given some consideration as to whether it could have been.
What sort of evidence should have been considered? What evidence did you adduce, Mr. Basu?
My lord, this appellant, my lord, before your lordship, he appeared as the only witness for the defendant.
Then what is the proof of fraud? That is immaterial whether that was considered or not.
No, he gave evidence that what he signed as which turned out to be a lease agreement was actually he was under the understanding that he was signing a premises tenancy agreement. That is one aspect of the matter.
And in your written statement, you took the point of fraud.
Yes, of course. Yes.
But it has been recorded by the courts that because Exhibit 2 was marked as exhibit, and
Exhibit 2 is the lease deed. Yes,
lease deed. And moreover, the defendants have filed written statement along with a counterclaim that their monthly premises tenancy in the premises, such
Yes.
and such, without mentioning any schedule for the purpose. It is clearly admitted that they were inducted by the plaintiff in the shop room, and thereafter they are occupying the same by paying rent as per Exhibit 2. So therefore, in your evidence, you admitted that you have been paying rent as per Exhibit 2.
My lord,
that is the finding, at least, of the court.
Yes, that's the finding of the
Factual finding, Mr.
court,
Basu.
but it is kind of unilateral. But in any event, the other this is one, and the other that I can suggest, Millard, is a new ground. Although a ground is there, ground 15, but I have reframed it, Millard, for your lordship's consideration.
What is the ground? Just tell us.
Learned Junior will submit the copy, Millard, to your lordship.
No, you just tell us the ground.
Yes, I can tell. I have the ground is blood. Whether admitted contradictions in respect of identification of the property, suit property, here your lordship will find, blood, that the deed of lease refers to room number 5, being the subject matter of the deed of lease. In the plain, it is said that it is room number 4. Then in evidence of the plaintiff says it is room number 5. And the court says, since the defendant has filed a written statement saying that they are in possession of room number 4, they should vacate room number 4. That is the question. My lord will kindly see that question, whether admitted contradictions in respect of identification of the suit property and the relevant room number, 5 or 4, as are evident on the face of the record of the deed of lease Exhibit 2, the plaint, and the alleged notice of ejectment. That notice of ejectment says it is room number 5.
Mr. Basu, was there any challenge specifically to the schedule of the plaint in the written statement?
Of course, yes.
And where is the argument on that?
My lord, that argument your lordship will get right from the beginning of the First Appellate Court's judgment at page 5.
Achha.
Up to the next page, first paragraph. Only leaving the last paragraph of page 5.
Vagueness of the suit property?
Yes.
Yes, it is.
That was specifically stated, argued.
But isn't it a question of fact, Mr. Basu? Is it a substantial question of law?
My lord, the question is, when there are admitted difficulties in identifying the suit property, admitted contradictions appearing from various records. First of all, the deed of lease. Second is the plaint. Third is the notice of ejectment. Now, notice of eviction. The court has said, although the notice of eviction is saying room number 5, but since there was no necessity for notice to be issued under section 106 Transfer of Property Act, so that can be ignored.
This reflection time, court was quite correct on that. Mr. Basu, you know the court was correct on that.
My lord, I say, my lord, that when there are specific contradictions appearing on the face of the record, not that they are our documents.
Mr. Basu, the only contradiction, I'm sorry, the only contradiction is in the notice.
No, in the lease deed also.
Lease deed also.
Yes, yes.
All right. So nomenclature, the numbering of the room, how is it material? The room
because there are several rooms. Because your lordship will see the suit property. If your
plain
lordship
says you are in plain
series
says
of-
room number 4. You are in occupation room number 4.
I say I am in room number.
You admit that you are in room number 4.
So it's not a question of admission. I claim that I am in possession of room number 4. Now, the lease deed is created in respect of room number 5. That's the lease deed is the very basis of their coming to court. They have it written there, room number 5. And then they issue a notice that you vacate room number 5. And then they file the plaint with room number 4. I say I am in possession of room number 4. Court says you are in possession of room number 4, so you vacate. And identification of the suit property has to be very correctly stated specifically.
But
when
it was, Mr. Basu, it was elaborately considered by the appellate court. We find it from page 6, as you rightly placed. Page 6,
Yes.
there's an elaborate factual consideration. Is there any scope of further reappreciation of evidence on that? Reappreciation of... Yes.
Scope is there because court has ignored the contradictions. That's the difficulty. Court has not given credit to the contradictions that are given due consideration to the contradictions that are appearing on the face of the record of several records. None of them is my record. It is plaintiff's record all. And they are coming with an indefinite case before the court, and court is passing a decree. This is something.
Have you annexed the lease deed, Mr. Basu, to the...
I haven't, but we can possibly.
If you have a copy, we'll look into that.
We can produce that any day. You will also melodify. But it is admitted that in the lease deed it is room number 5.
Yes, that is stated by the court also.
Court also. Yes, there is a finding.
Let us see just how it was resolved. If you find any substantial question of law, we'll admit. We'll just look into it. Just give us 2 minutes, Mr. Basu. We'll just.
Very well.
In the body of the lease deed, it was mentioned as room number 5. But in the schedule of the lease deed itself, it was mentioned as room number 4. That is the recording.
That is the recording. I mean, that does not in any way maybe helping the plaintiff's case. Because there is no law as such, at least to my understanding, that whatever is stated in the schedule and even if it is contrary to the statement in the body of the deed, will have to be adhered to.
No, Mr. Basu, we are sorry.
Identification is a serious issue. The property has to be identified.
Mr. Basu, not a substantial question of law. We'll discuss. We'll give our reasons for dismissing the appeal. The present appeal has been preferred against a judgment of affirmance whereby both the courts below decreed the respondent's suit for eviction of the appellant in respect of the suit property by holding that the lease granted to the appellant by the respondents by way of a registered deed within bracket exhibit 2 bracket closed had expired by efflux of time. Learned senior counsel appearing for the appellant argues that the first proviso to section 92 of the Indian Evidence Act 1872, which was applicable at the relevant point of time, comma, has to be taken note of, which provides that any fact may be proved which would invalidate any document or which would entitle any person to any decree or order relating thereto, comma, such as fraud, comma, intimidation, comma, etc. For sub next para, learned senior counsel argues that in the present case, comma, although the defendant stroke appellant specifically adduced oral evidence and proved the allegation of fraud which tainted exhibit 2, comma, the learned courts below failed to advert to such issue, and as such, comma, the judgments and decrees of both the courts below are bad in law on such count. Secondly, comma, it is argued that there is patent and admitted contradiction regarding the identity of the suit property. Full stop. Whereas the room which was let out in favor of the appellant was mentioned in the registered lease deed within bracket exhibit 2 bracket closed as room number 5 in the body thereof, comma, the schedule thereto mentioned the same as room number 4. Full stop. Next para again, comma, room number 4 was mentioned in the plaint as well as the written statement. Full stop. Next para, since the plaintiff stroke respondents rely on the lease agreement itself, comma, which is inherently contradictory as to the number of the let out room, comma, it is argued that such inherent contradiction denudes the decrees of both the courts below from legal sanctity. Full stop. Next para, upon a careful consideration of the judgments of both the courts below, comma, we find that the evidence of both parties were considered at length by the courts below. Full stop. Next para, since the allegation of fraud was made only in the oral evidence of the appellant, comma, read in conjunction with the findings of the courts below that the appellant admitted the existence of exhibit 2 in his evidence, comma, we are of the opinion that the oral evidence of the appellant as regards alleged fraud becomes redundant, comma, in view of his admission regarding the existence of exhibit 2. Full stop. Next para, that apart, comma, the alleged discrepancy was resolved by the courts below. Full stop. The first appellate court, comma, while scrutinizing the materials at length, comma, elaborately considered the issue. Full stop. Next para, in the opinion of the court, comma, although the body of the lease deed reflected the room as number 5, comma, it was evidently a typographical mistake, comma, since the schedule of the lease agreement itself mentioned the room as room number 4. Full stop. Both the plaint and the written statement mentioned the suit room as room number 4. Full stop. Hence, comma, it was an admitted position that the the stray mention of room number 5 in the body of the lease agreement was given a go by both the parties. Full stop. Next para, even the measurement of the room in question was considered by the appellate court, comma, which was the last court of facts, comma, and it came to the finding that the defendant had admitted that they were tenants in respect of room number 4. Full stop. Next para, even the counterclaim of the defendant stroke appellant was based on such claim. Full stop. Next para, thus, comma, it is thus, comma, the contention sought to be raised boils down to an appreciation of the evidence by both the courts below. Full stop. It is trite law that in second appeal, comma, there cannot be a reappreciation of evidence to upset the concurrent findings of both the courts below. Full stop. Next para, in any event, comma, we do not find in the light of the discussions above, comma, that any pure question of law, comma, let alone substantial, comma, has been made out in the present case. Full stop. Accordingly, SA 105 of 2024 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Consequentially, Can 1 of 2024 stands dismissed as well. There will be no orders to call. Sorry, Mr. Vasi.